But the court hall mic is muted, my lord. The court hall mic is muted, my lord. Sorry. Lordships, kindly, my lord.
matter. Tuesday, Miller. This is yesterday's matter. Yes, Miller. No, please wait.
Your Lordship, serial number 18, Your Lordship. Your Lordship, serial number 18, Your Lordship. Kindly have the matter next week, Your Lordship. The arguing counsel is traveling due to a contingency.
It's 2014. It's 2014. I can't adjourn a 10-year-old matter. Please wait.
Serial number
Lordship.
17, Marcus. LR application has not been put up. We have filed it on 25th March. No, there is another LR application.
Let us see, please wait.
Please.
May I make a submission, my lord?
Yes.
Yes. New matter, my lord. Yesterday, Lordships granted interim order in view of the Dharwad court's order, my lord, coordinate bench order. Same matter, I'm moving, my lord, today for 2:30, my lord. There is extreme urgency. At 2 days, my lord, holidays, and I'm facing threat of disconnection, my lord.
All right.
Grateful, my lord.
Serial number 19.
Serial number 19, therefore 1 week time, not 12.
2015. Please don't ask time for old matters. Please wait.
Lord, serial number 20, my lord. A request for 1 week's account.
Same thing. Please wait.
Lord, I'll get ready in the matter, my lord, next week. I'm not
What?
ready. I will get ready in the matter, my lord, next week, your lord.
Please wait. Let us see.
Please.
Serial number?
21. I informed the other side.
Please wait. Please wait. 2016 matter.
Serial number 23, my lord.
Yes.
My lord, for the respondent, counsel is appointed for the dentist, my lord. Tomorrow it may be given. Ready for the arguments, my lord.
Please wait. Let us see.
That's serial number 30. I applied for.
Relist.
Serial number 27. I'm the petitioner.
Relist.
My lords, 34 serial number, my lords. I'm appearing for the petitioner in this matter. My lords, I require 2 weeks time in this matter.
Relist.
37, my lord. 33. Serial number 36.
37.
37.
My lords, interim order needs to be extended in 34 months.
That's 36. Petitioner is dead.
It stated that the petitioner is dead. Steps
33
in 2 weeks.
My lords, 33 minutes.
Yes.
I appear for petitioner, my lords. I have informed the respondent. Seek for
Relist.
48, my lord. My lord, 48.
45. Relist.
My lord, 48, my lord. Senior mother is expired today, so 2 weeks.
Serial number 46,
Much.
your lordship. The petition already.
Relist.
Lord, serial number 50, my lord. I already informed to this petition.
Relist.
There's 2 weeks time.
52, my lord. I informed the petitioner. 2 weeks.
Relist.
Serial number
Serial number 59, and for R2 is dead, my lords. I'll file a memo along with this death certificate, a week's
No, no,
time,
please wait,
a week's time.
please wait, let us.
My lords, item number 73, council, item number 73. Council for respondent number 4 is not well. I'm seeking a short date.
Please inform the petitioner.
I've informed the petitioner.
Serial number 72. They are suffering from it. 2 weeks, 10 minutes.
The list.
72.
Two weeks in which petition stand dismissal. Second, 1 week. failing
My lord,
which-
serial number 10, my lord, in that, my lord, I have produced all the relevant typed portions, my lord. Only the R sheet front portion is not produced, my lord. Therefore, I have written
Granting you-
submission
I'm
also.
I'm granting you a week's time to whatever you want to do.
My lord, that is, my lord, relevant typed portion is produced, my lord.
ನೀವು dispensation ಹಾಕೊಳ್ಳಿ ತಗೊಳ್ತೀನಿ.
Much obliged, my lord. Much obliged.
11 to 14,
Serial number 11, my lord, memo for withdrawal.
requested petition dismissed.
Serial number 12, my lord, I may be permitted to withdraw the
As requested petition dismissed as withdrawn.
obligation.
13 and 14. Needful to be done within 3 days, failing which petitions are then dismissed.
Lord, serial number 15, I appear for the petitioner. I'm informed that he's been acquitted, my lord. It's become infructuous.
The land counsel for the petition submits that the petition has become infructuous. According to its submission, petition is dismissed and become infructuous.
Please, great.
To keep the, despite grant of 4 opportunities, needful is not been done. If no alternative, petition is dismissed on obligation.
16, my lord. 16 is very urgent, my lord.
16.
Because
now-
disconnection of a meter, my lord. They
Yeah,
want to
second list,
transfer
second
meter
list.
to the,
The second list,
sorry, sir.
1 week ಕೊಟ್ಟಿದ್ದಾರೆ comply ಮಾಡಿ.
My lord, serial number 7, allow me 4 weeks' time. I'll comply now.
why 4 weeks?
My lord, I have to.
It's come up for the second time, isn't it? Third time,
No, second time.
2 weeks. 2 weeks.
My lord, 3 weeks at least.
It's
I need to consult
2019.
my senior role.
It is 2019 matter. You take-
14%.
So you can take 5 years to comply with the office objections.
I'm just asking 1 more week.
I'm only granting you 2 weeks' time.
List number 1. Question matter, serial number 1.
Sir, here for the petition. My lords, this is a case, my lords, where Soham Infrastructure, the company, my lords, there are 2 other companies which were operating power plants, my lords. These 2 power plants, because the companies got amalgamated into this company, we sought for transfer of the wheeling and banking agreement. What happens is these companies, they generate electricity and they sell the electricity by using open access. So they had applied for open access. Now, for the purpose of applying for open access, etc., you have there's a wheeling and banking agreement which has to be entered into. We had a wheeling and banking agreement. To change the name from Ambutirtha to Soham, MESCOM asked us to apply for government approval. We applied for government approval. Government orders, my lords, will find that annexure G and H. What they are saying is, we will treat it as a transfer and we will ask you to pay transfer fees as per the renewable energy policy. My lords, amalgamation results in a winding up of a company, and after winding up of a company, that company
No,
says,
under the agreement that you had entered into with them,
I had an agreement, name has to be changed, a step.
in the agreement, what was it provided for in the event you transferring your rights under the agreement to somebody else?
I'm not transferring the name is changing.
What was the contractual term?
Contractual,
Permit such kind of a transfer?
yes, my lords, it permits. It permits, but it requires approval of the government. My
Where is
lords,
the agreement?
my lords, the agreement is not produced. My lords, the letter of MESCOM is there. My lords, may kindly take the letter
I'd
of,
like to see the agreement, so that will be the basis, isn't it?
my lords, the government, I'm not challenging the agreement. My lords. I'm asking my lords to look at the government order. My lords may just take
Okay.
annexure G.
You have an agreement with a party.
Yes, ma'am.
You want the parties in that agreement to be changed.
No,
I
no,
want,
not parties in the agreement to be changed, my lords. That's what, only the name of the company has to be changed.
is there
Yes.
is there any contractual term in the contract relating to this kind of an amalgamation or a change in the company's name? Is there any provision in the contract?
My lords, it's by amalgamation is by operation of law, my lords. The NCLT order, my lords may just take the NCLT order. NCLT order says all contracts
Produce
get
the-
automatic.
Produce that agreement. I would like to go through that agreement as to what term. In the event of such a transfer or an amalgamation or a selling of the company, whatever,
My lords, may I have it on Monday, my lords?
used.
Tuesday. Sorry, Tuesday.
Because if the contract provides for it, you don't have to do anything with them. If the contract bars it, I want to examine it, that is all.
Tuesday.
For preliminary hearing, number 2, Sri N. Suresha.
Last chance, relist on.
21st. Seal number 3, Sri M. E. Nagesh.
Appear for respond number 3. Objections filed to main petition.
Challenge is order passed by the RTA, granting variation. The page, start from page 20, my lord.
Next year,
21, annexure C, page 21. These are different subjects of variation applications. The conclusive portion is page 22. There is a common order in respect of several subjects. There is no discussion at all. That this honorable court, in similar circumstances, there is a general direction by the this honorable court to this, you will also kindly page 28, minute, annexure F, minute.
ನಿಮಿಷ.
ಎಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಸೇರಿ ಒಂದ್ ಲೈನ್ ಆರ್ಡರ್ ಮಾಡಿ ವೇರಿಯೇಷನ್ ಗ್ರಾಂಟೆಡ್ ಅಂತ ಹೇಳಿದ್ರು. ಅದರಲ್ಲಿ ಪೇಜ್ 28 ಅಲ್ಲಿ
Same day, the very petitioner also got
Refusal ಅಲ್ವಾ? They refuse to revise the.
ಅವ್ರ ವೇರಿಯೇಷನ್ ಗೆ ಇದನ್ನ ರಿವಿಷನ್ ಆಫ್ ಟೈಮಿಂಗ್ಸ್ ಗೆ ಅಲೋ ಮಾಡಿದ್ವಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಓದಿಲ್ಲ, ಪ್ಯಾರಾ 22 ಓದಿ, ಪೇಜ್ 22. ವಿಷಯ ಸಂಖ್ಯೆ ನಂಬರ್ so and so.
ಪೇಜ್ 22 ನಲ್ಲಿ ನಿರ್ಣಯ ವಿಷಯ ಸಂಖ್ಯೆ so and so ಇವೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಡಿಫರೆಂಟ್ ಸಬ್ಜೆಕ್ಟ್ ಡಿಫರೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ಸ್. ಆ ವಿಷಯಗಳಲ್ಲಿ ವೇಳಾಪಟ್ಟಿ ಪರಿಷ್ಕರಣೆಗೆ ಮಾತ್ರ ಮಂಜೂರಾತಿ ನೀಡಲಾಯಿತು ಅಷ್ಟೇ ಅವ್ರು ಮಾಡಿರೋ ಆರ್ಡರ್. ಈ ತರದ ಆರ್ಡರ್ ಅನ್ನ ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿ ಡಿಸಾನಬಲ್ ಕೋರ್ಟ್ page 28 minute referring to the division bench order, this lordship has considered that is where I have argued the matter, page 28 minute. Annexure F. Referring to that division bench order, page 36 is referred. Page 36 ಅಲ್ಲಿ Roman small 2 ನಲ್ಲಿ. In view of the orders passed that the chairman and members of the RTA stroke STA should sign at the each end of each page and 406 subjects having been placed in the meeting, there is no being no compliance by the first respondent with the direction issued in the so and so Doraiswamy case. Next, valid objections filed in the petitions before the first have not received any consideration in the impugned resolution or in derogation of the principles of natural justice. Again in para 8 ali, that so and so Lawrence HCGP submitted that direction issued by on 27/9/2005 in written number so and so was communicated to the all secretaries of the RTA in the state. He further submitted that a circular was issued bringing into the notice of all the RTAs in the state the general direction issued on so and so. He conceded that the respondent, while passing the impugned resolution, has not followed the direction issued on so and so. He submitted there is a bona fide lapse on this one, redo the things. Then the para 9 ಅಲ್ಲಿ call out ಮಾಡಿದ್ದಾರೆ ಏನಂತ. There is more than one reason to insist that the chairman and my member RTA should subscribe their signature in the bottom of each resolution passed in every subject. Each subject has to be discussed in separately. Then there is a separate order. There is a general direction issued by this honorable court. Now RTA has ignored it. It was having this one, it has been circulated all over the state. All the RTAs, whenever passing the subject, each subject has got a different context, a different case. Separate order has to be.
ಎಲ್ಲ ಒಂದೇ ಇಶ್ಯೂ ಇದ್ರು ಮಾಡ್ಬೇಕಾ? ಎಲ್ಲ ಒಂದೇ ಇಶ್ಯೂ ಇದ್ರು ಮಾಡ್ಬೇಕಾ?
ಎಲ್ಲ ಅಲ್ಲಲ್ಲ.
Each subject has a separate consideration. What you say is correct. If all of them relate to revision of time.
ಇಲ್ಲ ಬೇರೆ ರಿವಿಷನ್ ಆಫ್ ಟೈಮಿಂಗ್ಸ್ ಅಂದ್ರೆ ಬೇರೆ ಕನ್ಸಿಡರೇಷನ್ ಇರುತ್ತೆ. ರಿವಿಷನ್ ಬೇರೆ ಪರ್ಮಿಟ್ ಇದೆ, ಬೇರೆ ರೂಟ್ ಇದೆ. ಹಾಗಾಗಿ ಎವ್ರಿ ಸಬ್ಜೆಕ್ಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಸಪರೇಟ್ಲಿ, ಸಪರೇಟ್ ಆರ್ಡರ್ಸ್ ಆರ್ ಟು ಬಿ ಪಾಸ್. That has not been done. What happened? The order, it was not known to us. We are the objectors. Then we are not aware of that order. He filed writ petition that what secretary revision of timings that is allowed, what the RTA says. Normally in the revision of timings, once order is passed, matter will be referred to the secretary RTA for assignment of timings. He will hear all the existing operators, timings will be assigned. That has not been done. What he has given the representation to secretary, he endorsed my proposed timings. Then that, on the basis of this representation, he filed writ petition for writ of mandamus. This honorable court has directed that his matter may be, his representation may be considered. Taking advantage of that, the timings, the timings has been endorsed, stating that Honorable High Court has directed to this one.
Yes,
That is wrong. That is general direction has not complied with. He has to, that he. ಇಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಬರಲ್ಲ, ಸೆಕ್ರೆಟರಿ ಅವರೇ ಅವರು ಹಿಯರ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಎಲ್ಲ ಎಕ್ಸಿಸ್ಟಿಂಗ್.
Has it been passed without considering the objectors?
No, may submit this.
ಅವ್ರ ತಾನೇ authority. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಹೇಳಿ.
I appear for respondent number 3, Miller. Your Lordship may kindly see Annexure C dated 25/2019. The other side, the very petitioner was the order, was the applicant before the authority where in respect of 2 permits of the very petitioner granted the variation of revision of timings on the same day. He was aware of the order in 19. Your Lordship may kindly say. He got same day. First, Your Lordship may kindly say Annexure C. ಒಂದು ನಿಮಿಷ ಹೇಳ್ತೀನಿ.
ತಗೊಂಡೇ ಇಲ್ಲ, ಎಂಡಾರ್ಸ್ ಮಾಡ್ಕೊಂಡು.
ನಾನು ಹೇಳ್ತೀನಿ.
Were you also an applicant?
Yes.
I was the applicant. That I am not aware that RTS passed that order. ನನಗೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಆಗಿಲ್ಲ. ಇವರೇ ಫಸ್ಟ್ ಟೈಮ್ 2023 ನಲ್ಲಿ has given the representation, endorse that order.
Why should you entertain the petition after 5 years?
No, after this given effect in only in 2023.
ಆದ್ರೂ 1 ವರ್ಷ ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ, ಆದ್ರೂ ಅಂದ್ರೆ ನಮಗೆ ಅದು ಗೊತ್ತಾಗಿರೋದು ಈಗ ಮೊನ್ನೆ ಆಗಿರೋದು ಶುರು ಮಾಡಿ.
Appealable order, division bench.
No, 2019 ನಲ್ಲಿ this permit was in his father's name. This third respondent's father.
ಏನೇ ಆಗಿಲ್ಲ 2019 resolution, why should you interfere now?
No, that order is
After half a decade.
2023. That order is also, your lordship.
Why do you say it is with effect
It
from
is against.
Why do you say it's with effect from 23?
The endorsement, your lordship kindly see, endorsement may.
ಅಲ್ಲ, ಈ ಆರ್ಡರ್ ಏನಂತ ಹೇಳುತ್ತೆ? Does it give the date of effect from a future date?
Please, my lord.
This order basically indicates that the timings are revised.
The timings not revised. That whatever the time is prayed for, it has been endorsed by secretary in the year 2023.
ಇಲ್ಲ 19 ನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಏನಂತ ಆಯ್ತು?
ಅದೇ revision of timings allowed. ಒಂದೇ ಲೈನ್.
ಇದನ್ನ ಎಫೆಕ್ಟ್ 23 ಇಂದ ಕೊಡ್ಬೇಕು ಅಂತ ಯಾರು ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, ಇವ್ರು ಈಗ ಮಾಡಿರೋದು ಸೆಕ್ರೆಟರಿ ಅವರು.
ಇಲ್ಲ, I can't entertain a petition.
That is challenge.
Appealable order.
No.
Section 89.
This has been considered by this court regarding appealable order.
You want me to dismiss this petition on the ground of delay, or you want to do?
No, that is, your lordship kindly see. When the order is without against the direction issued by the court.
I will not entertain this even if it's an illegal order because you.
Page 27, your lordship kindly take. Page 27.
You will have to satisfy me on the delay. I am not satisfied.
That's why delay I am telling that, I am submitting that. That is on 7/6/2023. That has been given effect to. Your lordship kindly see. Page 27, Annexure E. ಪ್ರಾದೇಶಿಕ ಸಾರಿಗೆ ಅಧಿಕಾರ ವಿಷಯ ಸಂಖ್ಯೆ so and so. ಸಭೆಯ ನಡಾವಳಿ ಅನ್ವಯ ಹಾಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ WP ನಂಬರ್ 18/4/23 ಆದೇಶವನ್ನು ಪಾಲಿಸುವ ನಿಟ್ಟಿನಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ
What is this 8490/23?
Yes, ma'am.
What is this WP 8490/23?
This is
WP number. What has happened in the year, application was filed in the year 2018. My application was kept pending. 25/2019, Annexure C, the RTA granted the variation including his 2 permit subjects as prayed for revision of timings. So matter was kept pending. I made a representation before the secretary in 2019. Kindly see, here is a case where RTA has granted the variation and kindly endorsed the timings. It did not do so. Again, after 3 years, since the petitioner, third respondent father was 73 years, permit was transferred to third respondent. He made a representation in the year 2012-22. That is 28/12/2020. He did not do so. Writ petition was filed. This honorable court directed, consider his representation as per the order passed by the RTA and endorsed the timings. Now on 7/6/2023, timings are endorsed and I am operating since for more than 1 year. He kept quiet and now he is coming up before this honorable court after 5 years against the order dated 25/2019. And he is also a grantee.
Though it is ordered in 2019, it has given effect on 7/6/2023. And it was made in his father's name.
What have you said about being aware of this order?
No, that is, though he endorsed on 7/6/2023, he started operation only as.
Where have you said that you were unaware? What is reason given by you for not challenging it within 5 years?
No, 5 years, it's my submission is order was not given.
Yellow
Government in the petition.
The petitioner.
Where have you said that you were unaware of this order?
that is, you will also kindly see the.
ಆಮೇಲೆ ಇನ್ನೊಂದು ತಪ್ಪು ಮಾಹಿತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪ್ಯಾರಾ 11 ಆಫ್ ದಿ
It is submitted that, see, page 8, para 7, page 7, para 8. It is change of timings is a variation. Order has to be passed to judicial. Moreover, granting the revision of timings as normally, the RTA directs the
Where are you reading?
ಇದು page 7 ಅಲ್ಲಿ para 8 ಅನ್ನು ಓದ್ತಾ ಇದ್ದೀನಿ. Last 3 line.
ಅಲ್ಲ ಇದು ground ಆಯ್ತು. Where have you said factually as to what exactly happened? Why did you not challenge it?
That para 9 ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ that the writ petition was filed the representation was filed on 2022. Order was not given effect to, and he obtains a direction to consider the representation with with a view to endorsement renewal dated 13/10/2020 with the same condition, namely including the timing. Respondent cannot make claim revision of timings. The order of the RTA 2020 ends with the.
Nothing.
No, that is, it was my submission. There was no order of variation in the existence due to the lapse of time. It was expired.
If you had objected to the revision of timings, you should have verified as to what exactly happened. You cannot keep quiet from 2019, especially when you were also a party in those proceedings. This was some other purpose.
This was not pronounced that way.
ನೀವು ಅದರಲ್ಲಿ ನಿಮ್ದು ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಏನೋ ನಿಮ್ಗೆ ಏನೋ ಹೇಳ್ಬೋದಿತ್ತು. ನಿಮ್ದು ಅಲ್ಲಿ ರಿವಿಷನ್ ಇದೆ,
ಗ್ರಾಂಟ್ ಆಗಿದೆ,
ಗೊತ್ತೇ ಇಲ್ಲ ಅಂತ ಹೇಳೋದು ನಂಗೆ ಸ್ವಲ್ಪ ಐ ಥಿಂಕ್ ಇಟ್ಸ್
what my para 3 ನಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ನಾನು. The petitioners and other existing operators have objected to the variation. Page 3 para.
You should have followed up with this objection, isn't it?
No, that was.
You should have followed up.
No, that was.
You objected. You are not a layman. You objected to the revision.
That common order, it was not notified, not given effect to. That's why, in page 3, what I said, the petitioners and other existing operators have objected to the variation on the ground of after the promulgation of comprehensive.
You have a choice.
No variation. Hence, they were under the impression the application of third respondent.
You have a choice either for go file an appeal.
No, petitioners were not aware of the contents of the order under Annex C.
I am not satisfied. I will reject the petition, or you have a choice, withdraw and file an appeal. Your choice.
File an appeal means to the tribunal. This, so far as a filing appeal is alternative remedy is concerned, this honorable court in that writ petition has stated that this is when the direction has not been followed, that general direction. The order of.
I am dismissing only on the ground of delay. That will close all your doors. If you want to withdraw the petition, go file an appeal and raise whatever grounds you want to raise.
Then you will also kindly see to alternative remedy to challenge the timings before the appellate.
ಏನ್ ಮಾಡ್ತೀರಾ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾನೇನು permit to withdraw, that's all. If you want me to pass not on merits, I'll dismiss on merits on delay.
My submission may be required. Permitted to withdraw the petition to file appeal before the appellate.
After arguing for some time, seeks permission to withdraw the petition and seeks liberty to avail of the alternative remedy available against impugned orders. Granting liberty to the petitioner to avail of alternative remedies, the petition is dismissed as withdrawn.
For order, seal number 4, Mahendra Gowda CR.
On 49/2022, submission was made that the proprietor of the petitioner concerned was no more and steps would be taken. Though more than 1.5 years have lapsed, no steps have been taken. Petition therefore stands abated.
Seal number 5, the Ramesha BL. The Ramesha BL.
Employed. Notice that 4 opportunities have been granted to comply with the office objections right from 2021, and yet the office objection not complied. It's obvious that the petitioner is not interested in pursuing petition, hence petition is dismissed from office.
Seal number 6, Shri P.S. Basuraju.
You've noticed that despite time being granted on several occasions from 2021, no steps have been taken to complete the objections. It's obvious.
Bill number 7, Shri Sunil Kumar Patel.
I'm appearing on behalf of the petitioner, my lord. The needful is done.
Needful is still to be done, office to verify.
Bill number 8, Shri Vivek Kolla.
Set up any kind of project 10 years back. Electricity Act itself will not specify that all the green energy must be encouraged. We had a wheeling and banking agreement. We'll have to wheel it through the grid. And there's also what was known as banking. We bank the energy with the respondents. And we are entitled to avail it for 1 long year. Recently, this thing expired. They came up with a new rule saying that banking will be only for 1 month. Wind energy. Energy can't be banked at all. Instantaneously.
Idle.
So we challenged that. At that time, in December, there was no rains. So the interim order, the judges felt that we'll hear the main matter itself. Aglilla. Eager rains have started. I am not entitled to wheel the energy. Therefore, I have sought for whatever charges I'll pay them. Your lords may permit me to wheel and then hear me whenever your lords are here, whenever my learned friend.
They'll have to sign the wheeling and banking agreement, my lord, which is now there. The KERC requires that the wheeling and banking agreement must be signed for wheeling of energy. Now, banking, of course, is one concept, which throughout the country is 1 month. It's not like we have come out with something new. As a matter of fact, we are the only state in the entire country which used to give 1 year of banking. Now, that stopped. The central government came out with a new regulation. KERC also made its regulation saying after the term of the contract comes to an end, for all new contracts, it will be 1 month. And it is across the board for every renewable energy sources. It is 1 month of banking of energy. Now, that is across the board. Now, they are not willing to sign the contract. But the difficulty here for my learned friend also is the fact that BESCOM is not a party. KPTCL is a party. Wheeling and banking are always signed with the distributor entities, which is, my lord, BESCOM and CHESCOM. In this case, BESCOM.
Difficult for you to enter into that wheeling agreement?
Please, my lord.
What is it difficult for you to enter into that?
It expires in 1 month. Whatever we bank, my lord, it expires. In fact, can I, my lord, persuade your lordship?
But if your argument is accepted, only for you 1 year will have to be granted, isn't it?
No, my lord.
If what he says is correct and it
No,
is.
everybody, my lord, is 1 year. Please look at, my lord, 1 year.
Forget about the old contracts. The new contracts also 1 year?
No, 1 year.
New contracts also?
My lord, new contract for new people, my lord, it may be 1 month. But then, my lord, that itself is wrong. My lord, please have a look at this judgment.
No, under the contract that you had entered into 10 years ago.
1 year.
Was the right of renewal granted to you?
My lord, the renewal, my lord, is a matter, my lord, under the
Right of renewal on the same terms, was it granted?
No.
Then?
My submission to your lordship is, question is, my lord, whether, my lord, 1 month or 1 year. Banking. My lord, please have a look at this judgment. Of course, it's not, my lord, it's a electricity appellate tribunal order. Please come to, my lord, what is banking? Please come to, my lord, the running page. It was from 1 year, they reduced it to 1 month. They said, my lord, you can't do that because renewable energy, my lord, under 86 of the Act, Electricity Act, renewable energy must be, my lord, encouraged.
You have an agreement which is no longer valid.
Correct, my lord.
Under the agreement, you had 1 year.
Correct.
Now you want by virtue of an interim order.
Yes.
A contractual term of your choice saying that you'll have banking of 1 year.
What I am submitting is, your lords may hear us because they, my lord, they brought out a new regulation. Can I persuade your lords? Just look at.
The agreements are in accordance with those regulations.
No, my lord. We are challenging that new regulation.
So
The old regulation, my lord, the regulation that exists, that which has not been amended. My lord, I am entitled to 1 year of banking.
Show me that regulation.
Please come to, my lord.
Which enables you for 1 year.
Please come to, my lord, page 48.
48.
One standard is it, Tandri?
Let them sign the agreement, Lord, without prejudice to their contentions. Ultimately, Lord, if they succeed, then it's only a matter of accounting because energy can't be stored. So it is a matter of accounting.
Lord, this was the format, my lord, which has been prescribed under the rule, under this rule, and that has not been amended.
Which is the clause for
Come to, my lord, page 48. Please come to, my lord, running page, that 53. Clause 9. Nodal agency shall prepare the standard agreement format within 30 days of publication of these regulations. After obtaining the approval of the commission, make standard agreement.
Where are you reading page 53?
53 ನಲ್ಲಿ clause 9 ಅಂತ ಬರುತ್ತೆ ನೋಡಿ.
Yes.
Nodal agency shall prepare standard agreement formats within 30 days of publication of these regulations. And after obtaining the due approval of the commission, make standard agreement formats available to the public. Now, my lord, I have filed a memo. Standard format agreement, my lord, is this.
No.
1 year banking.
Now, this is only the terms and conditions for open access. Where is the agreement stipulated statutorily for enabling you for banking for 1 year? There is no statutory right that you have
This
for
is
1 year.
not the statute. This, my lord, is the regulation which continues to be enforced.
Which is the regulation which enables you as a matter of.
Lord, clause 9 says, my lord, there is a format. That format has been approved, my lord. Please take, my lord, my memo.
This is the old one.
Old ones.
This was 2008.
Yes, my lord. This, my lord, continues to be enforced. This has not been withdrawn.
No, there is a new
And
agreement.
then, please come
There
to
is a
my
new
lord.
agreement.
New format has been
Please come to my lord, running page.
We have filed the format.
Please come to my lord.
That format has been filed by KERC before your lordships.
New
My
format. is
lord
fine.
may take, my lord, page 70,
17.
70.
Yes.
Sorry, not 70, my lord. The state government, my lord, the central government came up with, my lord, rule. Please come to, my lord, page 87.
New regulation.
Yes.
Challenging. 2004 regulation.
Adjournment.
748.
Central government.
89, Lord. 87 is the regulation. My learned friend is right now.
87.
87 at regulation 8 banking, where it's specified it's for 1 month.
This has been challenged before your lordships.
No, this has
Because
not been.
Exemptions regarding the
It's not been challenged.
virus of this.
My lord, that's pending before your lordships. Under, my lord, under almost a set of circumstances, please look at, my lord, the judgment of Aptel, where their lordships, my lord, the Aptel have held. That, my lord, 86, my lord, mandates. That, my lord, there must be, my lord, encouragement of, my lord, section, my lord, renewable energy. And if your lordships come to, my lord, the last page.
This judgment is before the central government regulations. This judgment is before the central government regulations. Central government regulations 2022.
Correct.
This is before the regulations.
My lord, in this, their lordships, my lord, have specifically held, there must be, my lord, a data and, my lord, any change.
No,
They
where
must
is where is the consideration of regulation 8 year?
Idalla, idu 8 adalla. 8, my lord, is now made. That is challenged before your lordships.
Maybe so, but this judgment has not been passed on the basis of consideration of regulation 8.
What I am submitting before your lordships is, my learned friend said, all across India, my lord, it is 1 month.
Yeah.
It is not so. Everywhere, my lord, it is 1 year. Please have,
No, it was 1 year. Under this regulations, it has become 1 month now.
that is, my lord, whether this regulation will apply to, my lord, generators or, my lord, only consumers. Please come to, my lord, page 87 again.
Now, why don't you, like you said, enter into an agreement subject to your rights to
Lord,
determine?
what happens is, we went there. They are saying that, you will be treated as a new entity. We have been, my lord, there for the last 10 years. Then, my lord, you will be liable to pay, my lord, X amount, Y amount, and Z amount, which are not payable in terms of, my lord, the regulation itself.
What is there to show that they're
Can I persuade your lordships? Permit me to read, my lord, whatever the charges now, my lord, and hear me whenever you want. I am ready.
No, if I do that, that means you're now going to be wheeling your electricity without there being a contract on the basis of an interim order.
My
Isn't it?
submission to your lordships is, matter is seized up by your lordships.
True.
And
But there is no contract that you have.
Lord,
I'll be creating a contract now for the first time.
my submission to your lordships is, please have a look at section 86 for a minute, my lord, of the Electricity Act. '86 ಅಲ್ಲಿ 1E ತಗೊಳ್ಳಿ. Lord, the state functions of the state commission. State commission shall discharge the following functions, namely E bani. Promote cogeneration and generation electricity from renewable sources of energy by providing suitable measures for connectivity with the grid and sale of electricity to any person, and also specify for purchase electricity from such source, percentage of total consumption of electricity in the area of distribution of license. Therefore, my lord, this Supreme Court, my lord, all other courts have held. My lord, ultimately, my lord, it is this. Renewable, my lord, all coal creates, my lord, environmental hazard. Renewable energy is what should be, my lord, promoted. And 1 year, my lord, please look at it, my lord. Wind energy, my lord, is instant, my lord, energy, my lord, can't be banked. Instantaneously, it gets subsumed. From, my lord, 1 year, they have reduced it to 6 months, I mean, no, 1 month.
Idle.
Namdu idle. What I am saying is wind and,
Correct.
yes.
Solar, wind and
Huh.
water.
You're challenging regulation 6,
Yes, my lord.
11 and 12.
Correct. Of the,
KERs.
KERs, that is, my lord, page
Yes.
91.
Where is that?
91 is Banita.
Banking is 102. 12.
Judgment and degree.
85% is correct.
Clause 12, my lord, page 102.
Challenging proviso to regulation 6.
Six, 11 and 12. 12 is our one. 12 is the most important. Page 102. Banking shall be permitted only on monthly basis.
Whatever is unsold, they can sell it.
So your rights are protected only to the substance of the earlier agreement.
That's all.
My lord,
That is all.
my submission to your lordship says, is this, my lord, if this is, you know, if this goes, then my lord, they'll have to give me a yearly banking. Understand? That's the only issue. Whether, my lord, it should be monthly banking or yearly banking is the issue before your lordship. That is one. Now, my lord, please come to running page, my lord, 89, central
No,
government.
the banking facility is also provided under the regulation. You cannot independently create a banking period.
Lord,
If there are regulations governing the period of banking, merely because you had an advantage of 1 year in the earlier agreement, how can you enforce that?
my lord, please come to, my lord, page 87. Sorry, the first rule, which continues to be in existence even now. Please come to page 48. This regulation has not been, my lord, annulled. This continues to be enforced.
But the agreement that you entered into under this is to, has to expired.
Expired.
So how can you still rely upon?
Lord, can I put it in this manner? Rule 9, as I pointed out, page 53, provides for, my lord, a format. That format, they'll have to enter into agreement with me. That format, my lord, provides for 1 year banking. That's all I'm saying. This, my lord, the new one which they have made is contrary to, my lord, the earlier regulation which they themselves have made, and that earlier regulation has not been withdrawn. And the new regulation, my lord, applies only to consumers, according to me. Not, my lord, for
Here the
generators.
petition itself, maybe anytime next week and then pass final order. I can't grant an interim order in the terms that you are seeking.
All the
So
time.
I would virtually be writing a new agreement for
My
you.
lord, I am all the time saying, my lord, today, rains have started. I am generating electricity. I can't send it anywhere. There are about 100 people, my lord, working there. All that I am saying is whatever, my lord, is the charges, my lord, they are charging now, subject to, my lord, your lord's
No,
orders.
my apprehension is if I allow you a banking period of one year,
No.
there'll be several other idle
No, my lord.
project
Your
generators
lordship
like you.
may not say that, you know, it's 1 year. Have it, my lord, anytime convenient, your lordship, I'll argue the matter.
I'll have it on Tuesday, Wednesday, whenever you are ready.
Aito, Ali Tanka, at least they let them give me wheeling
No,
because,
I'll have it on Wednesday and decide it once and for all.
Lord,
Because interim
Already-
that you are seeking for, I can't really grant. Because I'm virtually creating a new right by virtue of an interim order.
Lord, I am not asking that, you know, your lordship should give me, my lord, 1 year of banking. Your lordship will decide, my lord, whether I am entitled 1 year or 6 months. I mean, 1 month. If your lordship feel at that time that I am entitled 1 year, my lord, they'll agree, enter into an agreement. If your lordship feel that it is only 6 months or 1 month, that's what they'll do.
No, like you suggested, enter into the agreement subject to that period of 1 month, then that will be subject to the result of the writ petition.
Correct. In 1 month, it will get decided.
That will be a better option because there'll be a contract which you're
Absolutely.
bound by it. I can't create an interim order.
They have made an application under the new regulations for execution of a contract.
They want the benefit of the old contract.
No, they asked for a new contract. Right? That's under process by BESCOM.
When I enter into a new agreement, some charges, my lord, which are not payable.
Either way that you have to, because your tenure period is over, you can't get it as a matter of
My lord,
right.
Can I request your lordship, just, my lord, in the light of what fell from your lordship, please come to, my lord, running page, the central government rules, which, my lord, binds them also. Based on which, please come to,
You
my lord,
tell me from your contract after the expiry of 10 years, what is your position?
my lord, I am entitled.
You have no right of renewal.
I have, my lord. Under, my lord,
Please
the
show me
old
from the-
regulation, under the old regulation, 2000.
Show me from the agreement, which is a standard format. Show me the contract which enables for renewal as a matter of right without any payment of charges. Then it will become easy for me because the new regulations say
Please
that contract is protected only till the substance of the agreement.
come to, my lord, page 52, clause 9. An application for open access shall be filed to the respective nodal agency by the intending open access customer with the copy marked to the distributor licensee of the area. This is, my lord, what it is. Then please come to, my lord, subpara 9. In the light of this, nodal agency shall prepare the standard agreement format within 30 days of publication of these regulations. After obtaining the approval of the commission, make the standard agreement formats available to the public. That was the format, my lord, which continues to be in force even now. Please.
No, he disagrees. He says the new format that is.
Page 42, my lord.
Lord.
Let me just show your lordship 42.
This is the format. This has not been withdrawn.
That's what he says.
There's a new
It's
format.
no,
KERC has filed it before your lordship.
Look at,
Page?
now,
My lord, KERC in its objection has filed it. But I would your lordship only look at page 42, my lord.
please come to, my lord. First, let us go, my lord, step by step. Please have a look at this format for a minute. It's yearly banking.
No, their agreement, which is the format itself, is already on record.
This is, my lord, the agreement. This is the format, not the new one. Banking, my lord, your lords get that at page 10. Six point 2.2, page 14 of the memo. Energy generated at the plant shall be banned on water, wind, air basis.
Page.
That was, my lord, 14 of the memo, my lord. 14.
Banking.
Banking. Otherly 6.2.2, energy generated at the plant shall be banked on water, wind, air basis, and will be permitted to carry forward from month to month within the same water or wind year. No carry forward, the banking energy is permitted from wind or water year to wind or next year.
Which is the clause regarding renewal?
11.
My lord,
Clause 11.
let us have a look at, my lord, 11 itself, page 53, if my learned friend says. 11 doesn't apply here. I have to make an application. Clause 9, my lord, is what applies, page 52.
And may be renewed for further period on the terms and conditions as may be mutually
Mutually
agreed upon between the parties
So you-
and approved by the commission.
So you don't have a matter of right for renewal on the same terms. If I were to grant an interim order in the terms that you are seeking for, I am virtually renewing the agreement
My lord,
without the approval of the commission and on.
can I request your lordships look at, my lord, clause 9 at page 52? Other, main information.
Yes.
An application for open access shall be filed to the respective nodal agency by the intending customer, open access customer, with a copy marked to the distribution licensee of the area. Then clause 9 says, in terms of this agreement. So they'll have to execute the agreement in
The
terms of this.
agreement was executed, the agreement has come to an end. The agreement which you had in your favor says it can be renewed only subject to the mutual agreement of the parties and the approval of the commission. You are now at that stage.
Lord, can I put it in this manner? Clause 9, my lord, empowers me, my lord, to again, my lord, apply. I have applied. Then, my lord, they'll have to enter into an agreement in terms of this. That's all I'm saying.
KERC says there's a new format that is
That
prescribed.
is what is essayed before your lordships. That's what I'm submitting before your lordships. That, my lord, is contrary to, my lord, the very section 86 of the Electricity Act, contrary to, my lord, their own earlier, my lord, regulation which has not been withdrawn.
I'll
And,
have
my
it
lord,
on-
they rely upon a central government rule, which, my lord, applies only to customers.
I'll have it on Wednesday for final disposal if you want. Tuesday, Wednesday,
Let them
whatever.
sign the agreement, or it doesn't be a mutual benefit. Ultimately, if they fail,
Wednesday, I'll argue them.
Wednesday.
90.
18.
You can come at 4:30.
My lord,
You can come at 4:30. I'll take it up after 4:30. On Wednesday.
ಮುಗಿಯೋದಿಲ್ಲ 4:30 ಸ್ವಲ್ಪ ಬೇಗನೆ ತಗೊಂಡ್ರೆ ಆಗೋದಿಲ್ವಾ? ಅಲ್ಲ ತಮ್ಮ
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದ್ದಂಗೆ ಅದಕ್ಕೆ
ಆಯ್ತು.
I'll sit 1 hour extra and take it up.
ಆಯ್ತು. Grateful to you.
Bill number 9, Shri Manmohan PM.
Oh, 19. Oh, I'm sorry, Lord, I have some difficulty.
20th ಆಗ್ಬೋದಾ?
Can it be the week after? The 24th, 25th, 26th?
ಬಹಳ ದೂರ ಆಯ್ತು.
ನೀವೇ ಒಂದ್ ತಿಂಗಳು ಬೇಕಲ್ಲ ಬ್ಯಾಂಕ್ ಮಾಡಕ್.
ಬ್ಯಾಂಕ್ ಮಾಡಕ್ ಒಂದ್ ತಿಂಗಳು
No, you agree on a date, I'm ready any day.
20th.
20th ಮಲ. Great.
Bill number 9,
Lord, the last occasion, Lord said, Lord asked me to verify if, Lord, there is any rebate. Lord, this section 11 order, wherein, Lord, the government directed us to supply power mandated to this grid. And Lord, now, Lord, that order has been withdrawn.
Withdrawal of the order.
How?
Right?
Now, Lord, I just pass on a memo, Lord. Put it. But they have not. There is a rebate of 2% in some of the bills, Lord, that I had raised.
What do you
Therefore, to that
propose,
extent, it will
Lord?
remain.
The rebate it is already availed of. What should happen to that?
Lord, what has happened, my lord, is the government order has now been withdrawn. That operated for a particular period. Government fixed a rate which was tentative to be ultimately fixed by the commission going through the regular process, my lord. That's the provision of section 11(2). Now, my lord, the government fixed a tentative rate with 2% rebate, my lord, which is prompt payment rebate, which is for parts, my lord, forms part of all contracts. Even a regularly entered PPA has a clause. If I pay later, there is a clause for interest. If I pay regularly within that particular period, there is a rebate, which has been carried, my lord, in the government order also. Therefore, my lord, ultimately, whether he gets the rate that is fixed here as 4.86 and prompt payment rebate of minus 2% or more.
If I understood his argument, his case was the direction which forced me to supply electricity to you. Not only that, I am forced to give you the electricity at a particular rate and also a rebate that you have decided. If that portion of that order is violative of his right to supply electricity without any rebate to you, then the petition would survive. You cannot take advantage of a direction, a lower rate, and then say I withdraw it, therefore forget everything.
No,
If the direction was uncalled for, or while issuing a direction,
the
right to grant a rebate to yourself,
not to
uncalled for.
myself. My lord, kindly see, my lord, page 55 of the petition, government order itself says it's a.
Or he has a right to challenge it, isn't saying that the government may direct me to give electricity, but it cannot direct me to give a rebate. You want power because of an emergent situation, take power.
That's true.
But you are again granting a rebate to yourself.
My lord, if I'm, for example, my lord, I owe him 100 rupees. Income Tax Act says, my lord, I have to deduct TDS. Can he say you are deducting something similar?
Analogy. You are asking, you're forcibly taking electricity from him.
No, forcibly correct. My lord, there are two aspects.
Alright, rate also you can maybe fix by yourself. But can you fix
Not
the rebate
myself,
also?
my lord.
The government is.
Yes. No, there are two parts of 11. 11(1) is the prerogative of the government to, my lord, issue a direction in case of certain situations, which it had issued. It has no, my lord, power to actually determine tariff, because the act says the only authority which will fix tariff is the commission, not the government. That was the whole idea of taking out.
If that argument is correct, if they don't have the power to fix a tariff, they obviously cannot have the power to give a rebate.
No,
on the power that is supplied.
No, not what all that I'm trying to say is government only fixes the rate tentatively. That's what the government order also says.
What is it?
It says 4.86 with 2% rebate.
Does section 11 enable them to give a rebate for prompt payment or for delayed payment?
No.
Lord, that itself will be the subject matter of 11(2). Lord, if it is 5 rupees minus 2%, that is the rate fixed by the government tentatively.
No,
That's to be determined whether I get rebate, I don't get rebate.
A normal agreement, that is one thing.
Yes.
If it had action of section 11, how can you as a matter of right demand rebate?
No, this is tentative is all that I'm saying. If 4.86 minus 2% rebate is the tentative tariff that has been fixed.
Section 11(2) fundamentally protects their right, saying any adverse financial impact. While protecting them, you're giving a rebate to the.
That is tentative. That is tentative. My lord, there are two ways of, my lord, there are two ways of looking at it, my lord.
It's a total rebate that they have taken. That
But he has now filed a memo pointing out, my lord, some rebates that have been taken with regard to
15.66 lakhs.
Yes. That is what he is pointing out, my lord. The statement I have indicates, my lord, it is not so much. Definitely there is some rebate which I have taken because I paid in time.
Petition will survive only to examine this particular rebate that you availed of under 11(2). Suppose I were to hold that you have no right on this
There is
rebate.
no challenge to that.
Entire order is challenged.
There is no challenge.
They withdrawn the government order, therefore you are
No, my lord, there is a challenge.
A challenge.
There's specific ground also raised.
Basic challenge was to the order under section 11. If you withdraw that, then everything,
The government order itself is withdrawn. The question, my lord, there are two ways of mentioning a tariff. I can say rupees 100. Or my lord, I can say 80 rupees specified. Or I can say it is 100 minus 20%, which will again be 80. That is what they have done.
you are prepared to give up the rebate, refund the rebate, I'll permit the KRC to go into this question and then ultimately decide. But you cannot take the advantage of the government order, the rebate, and then say, no, forget it now that there's no.
Then we'll file objections to the writ petition on this issue.
Objections second.
Next week, my lord.
Or our hakbekala objections until they file objections.
ಅವ್ರು ಬೇರೆ ಕೇಸಲ್ಲೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
You know, there's no urgency for you now that there's no direction. You're only fighting for this 15 lakhs.
My lord, yes, my lord, it'll be for the rebate only.
Realist.
In fact, my lord, what has happened is the Honorable Court has already held in another matter that this order, section 11 order will not apply to not suppliers who are not interstate suppliers. Even I am so.
But
But the
there's,
state by the division
there's
bench.
No reference to the rebate, my lord, it's not been argued there.
let us,
Very well.
when will you file your objections?
I'll file it in a week's time, my lord.
21st.
2 weeks, sir.
21st. Grateful.
28. 28. Number 10, Shri Nayakenna.
I beg to appear for petitioner, my lord. In this case, my lord, the common area has been treated as commercial purpose, my lord.
Petition copy ಕೊಟ್ಟಿಲ್ವಂತೆ ಅವ್ರಿಗೆ.
ಆಯ್ತು ಕೊಟ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇವತ್ತೇ ಕೊಡ್ತೀನಿ.
Week's time is granted to comply with the officer objections.
ಅಲ್ಲ, my humble request, my lord, stay kindly may be granted because we are the apartment holder.
Not disconnect ಅಂತ ಇದೆ.
Sir,
Is
There
an
is-
interim order.
ಆಯ್ತು ಸ್ವಾಮಿ, ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Disconnect.
That may be.
ನೋಡಿ ಎಷ್ಟೇನ್ ತೊಂದ್ರೆ ಆಗುತ್ತೆ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿರೋದು ನೋಡ್ಕೊಂಡಿಲ್ಲ ನೀವು.
ಇಲ್ಲ ನೋಡ್ಕೊಂಡಿಲ್ಲ.
Reporting compliance, seal number 11.
I appear for petition. Lord, he could be discharged under Price Sheets and Money Circulation Banning Act. And investigation to be carried on insofar as offences under section 420 is concerned.
This petition is filed challenging the registration of a criminal FIR for offences under section 345 of the Price Sheets and Money Circulation Schemes bracket Banning Act. And also for offences under section 420, 120B, credit section 34 of the IPC. PP at the outset concedes that the FIR registered offense under section 345 of the Price Sheets and Money Circulation Schemes Act would be incorrect in the light of the judgment rendered by this court. And he submits that the investigation will be confined only to the offences under section 420, 120B and section 34. Charge sheet in ಹಾಕಿಲ್ಲ ಅಲ್ಲ?
ಸ್ವಲ್ಪದ್ರಲ್ಲಿ ಹಾಕಿದೆ. ಲಿಸ್ಟ್ ಕೊಡಿ.
This is ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ?
Lord, in 4877 charge sheet is filed.
48? Oh. In the light of the above, the FIR and the charge sheet insofar as it relates to incorporating the allegation that offences under section 345 of the So-and-so Act are alleged against the petitioners shall stand washed.
Crime 163.
Are under the same FIR, the same charge sheet. Wherein the allegation is made that 8 lakh rupees I have taken, which is already paid back before the court. And parties have entered into compromise, which is an amount of.
ಯಾವ್ದ್ರಲ್ಲಿ?
4877, 4876, 11.
ಇನ್ ಕಾಸು ವಾಪಸ್ ತಗೊಂಡಿದಾರ?
ಅದರಲ್ಲೇ ಇದೆ, point out.
Then what is there to be prosecuted?
No, that might not absolve them of the offence. 420 ಅಲ್ಲ. Lord, it is the offence against, these are all offences against the society, not public at large.
ಅವ್ರ ಕಾಸು ವಾಪಸ್ ಬಂದ್ರೆ ಬಿಡಿ, ಇದ್ರಲ್ಲಿ ಯಾಕೆ ಅವ್ರು ಇಟ್ಕೊಂಡಿದ್ದು?
Then where was the necessity to challenge there? ಇದ್ರಲ್ಲಿ
Where is settlement that you arrived at?
It is before the court, it is reported.
ಎಲ್ಲಿ?
For trial court,
Who appears for the complaint? Who appears for the second respondent in 4877? Notice ಹೋಗಿಲ್ಲ ಅವ್ರಿಗೆ.
Nitin Vaidya,
Received the amount from the, even
No,
received
but-
the amount from the court also.
If he comes to the court and tells me that,
Because that has to do with having regard to this, filing in the court.
you know, consider the.
Lords may single out this matter and
That the offence under section 420 would also not survive, since the parties have settled their differences and the amount complained of in the complaint has in fact been refunded to the complainant.
And joint memo was filed.
He also submits that the joint memo to this effect was filed before the learned magistrate. In view of the above, issue notice to the second respondent. 11.1 Allah. 11.3.
7.3 is under the same affair. I want to bring you about penalty.
Who appears for, ಇದರಲ್ಲಿ ಏನ್ settlement ಆಗಿದೆಯಾ ಆಗಿಲ್ವೋ?
Same under the same affair.
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ? ಮತ್ತೆ let them investigate and then see whether no, the order of this court is already to that effect, isn't it? They can examine whether there's an offence under 420 or not.
yes, in terms of.
That, there is a technical thing about penalty.
Yes.
Petition number E1 on 4. E1 on 4.
Yes.
This is the complaint of the basis of which FIR is registered. Kindly see para 2 and 3. Unnumbered para 2 and 3. A complaint was received under 2015 and investigation was started. And FIR, even before registering the FIR, certain action was taken with the investigation. That FIR was challenged. After the FIR is registered, that FIR was challenged. And that FIR is forced by this honorable court, giving liberty to the prosecution to continue the investigation on the basis of that complaint. Now, can you see the after this raid, top 7 leaders were arrested and rest on got absconded. They were executed on 16 of them by Panadi police station in case number 67/2016. Now, when this is passed, now they registered this on April 6, 2018. It is the second complaint. Which is not permissible, it is not contemplated on the CR. In this way, same offense, same incident.
Where is the first FIR quashed this
With liberty
for
to,
16?
with liberty to register the complaint.
I am not saying that. The enforcement agency, the complainant itself has said that earlier there was a complaint filed. On the basis of the complaint, action was taken, a raid was conducted. Raid was conducted even before registering the FIR.
That was quashed.
That was quashed and.
Liberty was reserved to them to
on the basis
register.
of that,
So a fresh FIR is registered on the basis of the liberty granted by this court.
no, that, on the basis of second complaint. Now, this complaint is day different, that.
Where is the first order that granted him liberty?
That there, in fact,
That is at page 40th and operative portion. This is Anand Bere Reddy's order, is it? Please come to page 40. The last 2 lines. The respondents may however proceed from the stage of having received the complaint in accordance with law. Whether the second complaint or not, they could have still gone ahead with the registration. What difference does it make? So long as the liberty is there for them to investigate.
even subsequent days, just another, whether they had,
No, after referring to Justice Anand Reddy's judgment, Justice Dinesh Kumar has passed this order where it was left open to the prosecution to investigate.
You're bound by the order,
Investigate, yes.
you can't really get over that.
The Lordship may refer to that judgment. Your Lordship has mentioned, but not refer to that.
ಇವೆರಡರಲ್ಲಿ ನಾಲ್ಕರಲ್ಲಿ ಅದಿರಲಿ ಈ 11.3, 11.4 ಫಸ್ಟ್ ಪೋರ್ಷನ್ ಆಫ್ ಬುಕ್ this could be submitted later. It is to be noticed here that this court in criminal petition 6170/2016 had reserved liberty to the authorities to proceed from the stage of having received the complaint in accordance with law. And in WP 36587-3659 number 2018, this court had in fact stated as follows, para 8. In view of the above, it is clear that the police are at liberty to proceed with the investigation of the complaint, but the investigation will be confined only for the offences punishable under section 406 and 420 of the IPC. The petitions are accordingly disposed of.
That so far as mine petition is concerned.
Same thing.
ಇಲ್ಲ ಇದು director. In fact, Malad, under the guidelines, the director Salal Malad, if he plays mischief, he can be booked under 420. I am a director of the company earlier. Now, so far as the criminal case as against a company and the directors can only be under the Companies Act matter. In fact, there is a decision by this.
The Companies Act.
Yes, my lord. If any violation of the Companies Act, it amounts to a fraud. It amounts to a fraud under.
That is in the management of the company. But in so far as it deals with your dealings with as a third
No, no, no. In fact, if a direct seller, my lord, commits.
You are referring
place-
to section 447 of the Companies Act. That
For-
is a fraud played in the management of the company which affects the shareholder and others.
Correct.
This can't be really equated to 447.
Now, this is under the guidelines of the central government. If a direct seller not misleads or unfair trade practices, he is responsible. I can't be
No,
responsible.
whether he is committed a offense under 420 or not, we investigate by them. Companies Act has got nothing to do with this.
No, no, so far as the,
Prevent them from,
there is no allegation against the petitioner. I am the director.
they will investigate and then file a B report. You can't stall an
Then
investigation.
your lordship would indicate that the keeping in view the judgment of this court, Anand Bhai Reddy's case. The
That's what
respond-
I've said. I've referred to both the judgments. I refer to both the judgments, both of Justice Anand Bhai Reddy and Justice Dinesh Kumar.
please.
Elder of them. 11.3, 11.3.
ಕಂಪನೀಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಸೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು.
ಎಲ್ಲ ಕಡೆನೂ in fact there is one writ petition pending, my lord. I think it will come before the, as per the roster. I'll move it tomorrow. There is an FIR against the very same company that under the, it is a pawnage business. So there is a stay, my lord. And I think in view of this order, it can be disposed of. I'll move it tomorrow.
For hearing.
Yeah. Remote continue. ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ನೋಡ್ಕೊಂಡು ನಿಮ್ಮ ಅಷ್ಟೇ ಬೇಡ.
For hearing on IA, seal number 12. We are certainly.
Lord, I appeal for the petitioner. This matter has been entirely heard, my lord, regarding the regularization of Kidwai in staff nurses, my lord. And every occasion it is.
Hearing on IA seal number 12. ನಿಮ್ದು ಯಾವ್ದು?
Sorry, my lord.
Who's for the petitioner?
Mr. Sathanalli, madam. I have told he has gone to America.
What is this IA for consideration?
IA number 2 of 23, your lords. Here for the impleading applicants. The proposed respondents are the members of the Dasanpura Merchants Association, your lords. Last occasion, lordships directed that it may be considered along with the main.
On which date was the order passed? In view of the order, it is 17/4/2023.
17/4.
The question of considering. Now, this is IA number 3. What is IA number What is IA number 3? The order was on IA number 2.
That was an IA number 2. I had filed IA number 2, Your Lord.
What is IA number 3?
Number 3. Copy.
Certainly.
To raise additional grounds.
Additional ground.
He has
It
made
was
an
filed by the
application to
petitioner.
raise additional grounds in the petition. IA dated 10/4 application filed seeking to raise additional grounds is allowed. Amended petition to be filed.
Great.
13.
Next one. Number 13. N. Subbareddy.
Indeed,
Not 13,
12.
this regards
13, sorry.
13. Shifting of APMC from Yashwantpura to Dasanpura, contrary to the APMC regulations, direction, the act.
Shifting of?
APMC in respect of only 4 items from Yashwantpura to another place called Dasanpura. It requires some hearing. If a date could be fixed, perhaps Thursday next week, we will complete once for all.
Post for. Various term.
20th.
Give you a date.
20th. Please.
For admission, seal number 14.
The petitioner, my lordship.
Yes.
Appeal to the respondent.
So 138, my lordship. Here, a company is not made as a party.
Matter which was day before yesterday, it was listed, my lord. I couldn't appeal because I had some medical appointment. The question posed by this honorable court is, I have not made the company as a party in this matter. I have produced a judgment before your honor. Your lordship may kindly see the memo where I produced the judgment. I will just take your lordship to the judgment.
Let us see the provision first.
Yes, sir. (141) of the negotiable instrument act.
It's 142, 141.
(141), my lord.
Yes.
Offenses by the company. If the person, subclause 1, if the person committing an offense under 138 is a company, every person who at the time of offense was committed with, was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and
Both the
punished.
person in charge as well as the company should be proceeded against.
Responsible to the company for the conduct.
If you don't go against the company and go only against the person responsible, proceedings are vitiated.
No, I have made the company as a party. The technicality flaws, I will explain your lordship.
Where's your
Lord-
complaint?
Yeah, I will take your lordship to my cause title first, my lord. Your lordship may kindly see the
Page number 4.
my lord, your lordship may permit me to file the memo with the petition which is filed before the lower court.
No, it's produced, annex A is the complaint.
I'm giving the entire set so that your lordship can see the check as well as the agreements and everything, where I can demonstrate the company is a party, madam. I may be permitted to file this. This is only the petition of the lower court. So that it's easy for me to take your lordship through that. Your lordship may kindly see the first is the complaint.
Yes. You made only Shirish Chitte as the
Yes,
accused.
yes, I will submit, my lord. This is my lord, page 2, your lordship is seeing, my lord, page 2. Sirish Chitte, Director of Leminion, IT Solutions. On this basis,
He is the person in charge of the company.
is the only,
If
he
you
is the
don't
main
make-
person, the director.
If you don't make the company,
I will submit. Your lordship may kindly permit me to. In this few documents, I will refer and I'll come to the judgment. I'll not take much time of this court, but I'll only go to the point, my lord. Your lordship may kindly see the same petition. Your lordship may kindly see the check which your lordship saw also. Before that, page 11, your lordship may kindly see a settlement agreement done by him on behalf of the company. Your lordship may kindly see page 11, annexure B. Down your lordship can see, he signs as a Sri Chitti Director, Lemonion Company. Then your lordship may kindly see the check. Page 12. That also he signs it as the Lemonion Company Solutions, my lord. Now your lordship may kindly see the memo which I produced, which covers this point. The judgment which they are relying is the Anita Handa case, which is the Supreme Court judgment that's been referred in this. Your lordship may kindly see my memo dated 19/7/22, my lord. 19/7/22. I filed a memo with the judgments, my lord. Total judgments.
7/22 memo ಹಾಕಿದ್ದಾರೆ.
The first judgment, my lord, it is T. Raghavendra versus KH. Your lordship may kindly see, this is the judgment passed by this honorable court. The cause title is very important, my lord. T. Raghavendra, son of Timmegoda.
Where is Supreme Court judgment, madam? First take me to the Supreme Court.
Supreme Court judgment, which is referred in this only, my lord. I have produced that also. Your lordship may kindly see, that is the second judgment. That is, the second judgment is 2012, my lord. 5 Supreme Court, my lord, Anita Hada.
Yes.
That is the judgment which they are relying, where they said that the company should be.
Which is the paragraph which says company should be made a party?
My lord, your lordship may kindly see.
Page number 47, lordship, point number 43.
Page number?
47, point number 43.
Paragraph.
Paragraph number 40. Yes. Page number 47, paragraph number 43, lordship. In my memo, I have produced, lordship.
Page 62, paragraph 62, they discuss about 63, they come with the section offenses by the company, my lord. There they come for the discussion.
Please come to paragraph 59.
Shall I read, my lord?
Yes.
In view of our aforesaid analysis, we arrive at the irresistible conclusion that for maintaining the prosecution under 141 of the Act, arraying of the company or as an accused is imperative. The other categories of offenders can.
The declaration.
It's a
Arraying
declaration.
a company is
Yes,
imperative.
Yes, ma'am.
There is no escape from.
No escape from that.
Then-
I'll demonstrate, my lord. Should I read the full paragraph? I'll go to the one more important paragraph in the same judgment, my lord. Your lordship may kindly see
No, continue reading that entire paragraph. Maybe it will help.
that I will read and then come to the paragraph which I want to refer, my lord. 59, my lord. The other categories of offenders can only be brought in dragnet on the touchstone of vicarious liability as the same has been stipulated in the provision itself. We say on the basis of the ratio laid down in CV Pare, which is 3-judge decision. Thus, the view expressed in Shioratan Agrawal does not correctly lay down the law and accordingly hereby overruled. The decision in Anil Hada is overruled with qualifier as stated in para 51. The decision in Modi Distillery has to be treated to be restricted to its own facts as has been explained by us herein above. Your lordship may kindly come to para 5, which is concerning this case. It's 5 of the same judgment. Anita Hada judgment itself.
Yes.
In the particular case, there, the last line, if your lordship may kindly see para 5. In the complaint petition, the company was not arrayed as an accused. However, the magistrate took cognizance of the offense against the appellant accused. In this case, if your lordship may kindly come to the first page of the judgment, Anita Hada. Your lordship may kindly see the opening page. It's only Anita Hada. There's nothing written right, director or company owned. The one which I'm referring, the judgment which of this honorable court, they have made the distinction there only, my lord. Your lordship may kindly see the relevant paragraph. Only few paragraphs I will just read, my lord. Page 21, para 15, my lord, of this honorable court's judgment. Page 15, my lord.
Page
15, sorry, paragraph 15, page 21, my lord. In page 21.
yes.
This is a similar case that of mine, and the cost title also I have shown you, lordship. It's written Raghavendra and all that. He's the director and the company. Company is not arrayed separately a party in this. Looking to the above two decisions, it is clear that the court has in detail gone through the materials on record, find out whether company has been made a party or without making company as a party, one of the directors extensively and individually made as a party so as to claim individual liability is the director without claiming any right against the company. On the basis of the entire materials on record, if the court is of the opinion that company is liable and as also stated in the complaint and the purpose of representing the company, the director is made as a party. The company is not made a separate party. In that eventuality, the court can consider that the company is made as a party and the company is represented by its director who has been looking after the day-to-day affairs of the company. If such conclusion can be drawn on the basis of the material on record, then quashing of the proceedings does not arise. Therefore, it goes without saying that principles that can be culled out from the above said rulings are that it is a bounden duty of the court to ascertain for what purpose the legal fiction has been created under 141 of the Act. It is also the duty of the court to imagine the fiction with all real consequences and instances unless prohibited from doing so. That apart, use of the term deemed under section.
Where is it stated here that the complaint need not be a party and the company need not be a party and only the director may be made a party? Show me that particular paragraph.
That's not the way the court has interpreted, my lord.
The Supreme Court has,
No.
Supreme Court has laid down the law.
Yes,
But arranging
I'm not going against that. 141 insists company should be, your lordship may kindly permit two paragraphs, my lord, which they have making Anita Hada is also referred in this. Your lordship may
Refer
kindly.
to, please tell me from the paragraph as to,
Only these are the relevant paragraph. I'll read only two paragraphs.
no, you may read the whole judgment, but show me the paragraph which says company need not be made a party. Only that director who is responsible be made a party.
It
Show
is
me
the
that.
pleading. That's what they say. You have to read the complaint. And if I'm reading, I'm pleading against the company just on the technicalities that I have made the company name first and the director down instead of making independently the company and the director.
No.
That will not come in the
Company
way.
is a
That's-
separate entity by itself, the person.
It's
in
a
charge.
juristic person, my lord. The company is a juristic person.
So
It
you
has
have
to be
make the
represented.
jurisdiction person a party first and then also array the person
That
who
is-
was in charge of the affairs of the company.
Yes, my lord. But 141 doesn't say that the separation should be done. It only says the complaint.
It says that.
That is why, my lord, if your lordship may kindly permit that, they have referred about Anita Hada and only decided it. What is the difference in Anita Hada is there was only one party is made the party. She was not represented like director or the company or anything, but it is different in this case. Actually, this honorable court, after hearing the matter, also directed me to produce a petition of this judgment also, which is filed before the Kalburgi bench, which is also I have got it, where the cost title is the same, the name and the director and the
It does
company.
not determine anything.
Your lordship may kindly.
My understanding of the law is you'll have to make the company as a party.
Yes, my lord.
And whoever you think was in charge, not necessarily the signatory. Whoever is in charge, you make them as a party. They will be prosecuted again, proceeded against with. It is for them to establish that they were not in charge and they'll be exonerated. You cannot let go of the company and go only against the employees.
Not against the employees. The director whom I have made a party, he was whole and sole in charge of the entire. That's my pleading also.
You had to make the company a party without the.
No, that is why, my lord,
There'll be a board of directors, there'll be so many people in charge.
there's only two directors, my lord, he and another person. He's
Not
the
in
one.
this
who's
particular
looking.
case, the company is being
Yes, my
run
lord.
by individuals.
In my petition, the opening line itself, I'm talking about company only, my lord. The technicality
All the
flaw.
more reason for you to have implemented the company as.
For that
accused.
only, my lord, if your lordship may kindly permit, I'll read one paragraph if,
Yeah.
and I leave it to your lordship, my lord, after that. my lord. This, that paragraph I'll complete, my lord, page 22, where I read half the way, my lord. I'll read it, my lord. It is also the duty of the court to imagine the fiction and all real consequences and instance unless prohibited from doing so. That apart, use of the term deemed in section 141 of NI Act has to be read in its context and further, the fullest logical purpose and import are to be understood. It is because of the modern legislation, the term used in the provision has been used for the manifold purpose. The object of the legislation has to be kept in mind for the purpose of advancement of substantial justice in respect of quashing the proceedings or terminating the proceedings only on technicalities, my lord. Then para 17, my lord. Para 17. In this, my lord, The above said provisions, if meticulously read, it is clearly indicates that if the person committing the offense is a company, then every person who at the time of offense was committed, was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offenses and shall be liable to be proceeded against and punished accordingly. Further interpretation of the provision is not necessary so far as the case is concerned. This provision imposes responsibility on the court to first find out whether the company is liable, and secondly, who is the person at the time of commission offense was in charge and was responsible for the conduct of the business of the company. Therefore, two aspects has to be considered by the court. Company has committed the offense and somebody is there to answer the liability of the company. Though in the said provision, it is not clear that the company has to be made an independent party, but it is imperative that company shall be made a party to the criminal proceedings. If the company is made as party, somebody should be there to represent and answer the liability of the company. The answer to who were all persons liable to answer on behalf of the company is depending upon the facts and circumstances of each case. Particular person may be looking after the affairs of the company. Any one of the director may be entrusted with the work to look after the affairs of the company. Any one of the director may be having a direct link with regard to the offences committed by the company. So far as the particular case is concerned, therefore the court has to analyze the factual aspect, find out whether there is any liability fixed on the company. Therefore, one of the director who's the root cause for the offense being committed by the company, it is also made a party to the proceeding. Therefore, in this background, now let me consider the factual matrix in this case. In this, my lord, 18th paragraph, my lord. As I have already narrated in the complaint, the categorically stated the complainant has a transaction with the company and on behalf of the company, manager has placed orders. In the present, accused has issued post-dated checks for the repayment of the alleged debt on behalf of the company. Therefore, it is clearly establishes accused under an individual capacity is not issued those checks, but it is on behalf of the company has issued those checks. After that, my lord, therefore, it goes to say that it goes without saying that company is the principal offender and the director who's actually issued the checks are having the knowledge of the transaction between the company and the complainant and knowing fully well the company is liable to pay such amount to the complainant has issued the checks. By virtue of 139 of the Act, at the initial stage, court has to presume those checks unless presumption is rebutted. It is to be presumed that it was issued for the repayment of the debt or a partial debt in favor of the complainant. In view of the fact narrated in the complaint, it's clear accused director has not issued checks in his individual capacity, but only as a director to answer the liability of the company. Those checks has been issued. Prior to the issues of such checks, it is seen that the notice has been issued to the complainant in similar fashion under the nomenclature Director, Alpine Wineries, so and so, my lord. Though it is addressed to the director, the body of the notice, it categorically stated the accused company is authorized to store and sell the wines. Then I'll come to the end paragraph, my lord. In the complaint, in the same paragraph, in the complaint also, primary liability has been fixed on the company and it is stated on behalf of the company, checks were issued by the director. Therefore, it goes without saying the primary liability is fixed on the company and the director has been made as a person who is answerable on behalf of the company. Petitioner's counsel is right in contending that the cost title is not properly constituted, though cost title contain the manner, director, Alpine, that thing, my lord. He contends the director is made an individual party to the complaint, but I fail to understand as how a director is made an extensive party to the proceeding when the complaint amendment categorically state the company is liable for the said transaction. Therefore, it may be a minor mistake committed by the counsel who are appearing for the complainant before the trial court. Instead of putting the name of the company in the first line, putting the name of the director underneath the said company nomenclature as director is mentioned in the first line and the company's name is mentioned in the second line. It is argued the learned counsel that an overall looking of the transaction between the parties and allegations in the complaint as well as the notice, it is crystal clear that the liability is on the company. Therefore, the court has to deem it proper and correct that the company so and so made a party to the proceeding because accused director was looking after the affairs of the company. He actually issued in favor of the complainant and therefore he is made as a representative of the company. Now they refer Hada case. Your Lordship may kindly see at page 14, para 9, my lord. They have referred about Anita Hada, my lord, and the consideration comes in para 10, my lord. May I read, my lord? On careful understanding of the above ruling, it is crystal clear company is a juristic person. Therefore, somebody should be there to answer the responsibility of the company. Therefore, it is made clear the person who's looking after the affairs of the company or who having main dealing with the company and who knows transaction between the complainant and the company can be made to answer the liability. The juristic person cannot be sentenced to undergo imprisonment. Therefore, in the event of the violation of the judgment conviction passed by the trial court by means of non-payment of any amount, somebody should be there to take the responsibility. Therefore, in this context, it is categorically stated primary liability to be fastened on the company. Therefore, the other person who is responsible to answer the liability of the company shall be made as an accused. Therefore, absolutely no distinction can be made with regard to the above said judgment. Then para 12, my lord. The main principle laid down by Honorable Apex Court that if complainant under 130 Negotiable Instrument Act is filed against a company and its director, and if the petition is filed for quashing of the proceedings under 482 by the director, High Court may, on the facts and circumstance of the particular case, on overall reading of the complaint, may refuse to quash the proceeding because the complaint contains basic arguments which is sufficient to make our case against the director.
That is not what para 59 says.
That is what, my lord?
That is not what para 59 of the Supreme Court judgment says. Para 59 is not considered by the learned judge.
This court has considered what it says.
But yet not, para 59 is not considered.
No, the entire,
Para
the judge.
59 does not make any exceptions.
My lord, if the director's name is put behind the company, that technicality should not come in the way. That is what
That's not what.
because 141 doesn't say specifically a separate party to be made. Company should be made liable. That is there. That is a distinction here. In this case, Anita Hada, they have not made the company at all a party. Neither she is referred as a director. But this case and my case is similar, where I have written the company's name. Behind I have written the director. And if you lordship may kindly see the petition, the opening line of my petition, I'll just read that line, my lord. In the first paragraph itself, the accused is the director of the Lemonion IT Solutions Private Limited. Accused company is in the business of providing the web, internet, and mobile application, which accused customized to meet the requirement of the customers. The opening line itself, I'm stating about the company
If
only.
conviction of this accused, then it which the companies are convicted.
My lord.
If let's assume your complaint is granted, convicting this gentleman, what's his name? Shirish Chitte.
Chitte.
Would it tantamount to convicting the company?
No, but here, yes, that cannot be done. What I am
The
submitting
company can't be convicted.
is, so somebody is to represent it.
No, without the company being convicted, can its employee be convicted?
No,
That's
company is a must, my lord, but company being a juristic person, some director has to represent it.
have to make
The cost title should not come in the way of the technicality to take away the right of the complainant, my lord. The only submission is, my lord.
You should seek for conviction of the company. If the company is convicted, as a consequence, who is the director who is responsible shall also suffer the liability of the conviction.
Very well, my lord.
One cannot go without the other. Both of them
Yes.
should go together.
Yes, my lord. If this is, the quashing is not done, when the trial starts, my lord, in that the honorable court is going to go into the trial to find out whether the company is liable or the director. It is not going to make the director liable if the company is liable. And the same director signed the checks. He has entered an agreement on behalf of the company. Now on technicalities, he want to escape from the payments. On only the fact that I have written the company name first and the director's name down, I am accusing the company only. My entire complaint is pertaining to company only. So this is for the magistrate to go into the inquiry and find out, and then only it will be decided. This is too preliminary a stage to say whether I'm only making the director liable. I'm making the company liable, and the director is a person representing the juristic body. Because company cannot be here. That's what the distinction this honorable court has made. Just because the technicality, the advocate has written the cost title, company and the director, should not take away the legislation's idea of 141, where the company should be made liable and not the director. If the director is signing everything on behalf of the company and he's the one who's representing the company also, then I am representing the company only the cost title is defective, which takes away my right.
Anything else?
I am relying on that judgment as it has already consumed both the Supreme Court judgment, my lord.
Criminal petitions allowed. Proceedings quashed.
For further consideration. Raghunath Joyce.
But I appear for the petitioner, my lord. This matter has come on several occasions. The matter relating to regularization covered by decision I have already put. The only contention they sought to raise is that The payment was made by stipendiary manner, but the fact that the posts are there is not disputed. Their own reply said that posts is there. Then your lordship, my lord, initially said that let them pay the pay scale and all. Then that is also not paid. I am not worried about that, my lord. Under the equal pay for equal work, I will get it. Now I am seeking for regularization, my lord. If your lordship permits me, kindly see these are all persons appointed in 2006 as stipendiary nurses, my lord. One appointment order I have produced, 2004 and 6, page number 19. In fact, they were initially put on 2 years service, that is probation, though not use the word probation. They were initially put on provisionally for 2 years and they continued from 2004 and 2006 onwards. Now we are almost 20 years of service we have rendered, my lord. If your lordship permits, I will read one order of appointment for kind reference, page number 19. Appointment for the post. Kindly note, my lord, according to Umadevi, what is very important is post. Post of staff nurses, bracket stipendiary. That is mode of payment is stipend. Instead of paying full salary, they are paying the stipend. But the post exists. To the post only, I have been appointed. Kindly see next para. Office advertisement. Your lordship may kindly note there was an advertisement also. Then, my lord, Srimati B.J. Rani appointed provisionally for 2 years as staff nurse in stipendiary in Jayadeva Institute of Cardiology. Stipend of so and so. She will report. These are conditions and all there, my lord. Then, similarly, my lord, second petitioner, he was appointed in 2005.
You entered into a contract?
Yes, my lord. The word said it is not stated on contract, my lord. Your lordship may kindly see the para 3 of the order of appointment at page number 19. The appointments of staff nurse will be as stipendiary norms and a stipend of 3,000 will be paid.
No, what is para 8?
Para 8, she to execute agreement that they have taken. Yes, they have taken.
Where is that agreement? Have you produced it? The agreement is on record.
Agreement illa. But kindly see, my lord, annexure A3, similar orders of appointment, A3, A4, A5. The others are appointed. The first petitioner in 2004. All others appointed in 2006, my lord. From time to time, our stipend is being given.
Now, after 2 years, was it extended?
Then, my lord, I initially approached this honorable court in WP number.
After 2 years, was there a separate OM issued in your favor?
No, there is no separate order issued. We continued. We are continued like that, man. Then your lordship may kindly see, so far as the stand of the respondents in the earlier petition, I filed 18,961 of 2022, which came to be disposed of as per annexure F, my lord, page number 51. Your lordship may kindly see page number 55.
How many petitioners are here?
Yes, my lord.
How many petitioners are here? 10.
There are only about 10 persons, my lord, 10 persons.
Annexure C is referable to them. Annexure C.
Annexure C, my lord.
Yes.
That is full details, my lord, I have given. C onwards is the full details of every candidate because from the date of appointment, designation, date of joining, and completion. On what date we completed 10 years of service, I have given because 2005 I have completed 10 years in 2015, second petitioner in 2016, and second to almost ninth petitioner to 16. Last person Lokesh completed in 2017 because he was appointed in 7. So then, my lord, I produced annexure D to show the number of posts, my lord. It is published by the institution itself, Jayadeva Institute of Cardiovascular Sciences and Research, particulars of the post, permanent and contract, annexure D. Annexure D, my lord. So far as staff nurse is concerned, page number 43, item number 90 and 91. Page number 90 and 91. Staff nurse, 225 posts. Number of persons working 40. Your Lordship may kindly see in the 225 itself, persons, regular persons 40, contract 176, total 216 posts. 225, there are still 9 posts vacant, out of which, my lord, except 40 people, most of the persons like me, my lord, 176 persons, they have appointed on contract basis. Now come to the reply statement filed by the institution in the earlier writ petition, which your Lordship will get annexure E, page number 44, my lord. That clears the issue itself, because the earlier, though the Honorable Court specifically did not regularize my services, it has directed consideration of regularization having regard to the pleadings of the respondents. Come to page number 45, para 3. Para 3, ma'am. It is respect, your Lordship got, my lord.
Yes.
It is respectfully submitted that it is true that the petitioners are working as stipendiary staff nurses on contract basis in the institution. Appointments of the petitioners are against sanctioned post of stipendiary staff nurses. And the said appointment is purely on contract basis and renewable every 6 months with a day's break. As such, there is no continuity in their service and there is no provision in the rules for regularizing this. Your Lordship may kindly note this, because they have taken in the reply statement now filed also a endorsement saying that there is no provision for regularization. So for that aspect, I will answer now itself, saying that there will be no provision for regularization. It is in persons of the judgment. Since the post is created only on contract basis, this also your Lordship may kindly see, they refer to a post being created in 2021, my lord. Page number 45, para 3. They refer to a government order of 21, whereas I have been appointed in 2005 and 6 respectively, 25, 6, 7. Therefore, this is a subsequent creation of post which has nothing to do with our appointment in 2005 and 6, for which I had already shown that there were 226 posts existing as on that day. Then, my lord, para 4 is very important. It is respectfully submitted that 565 posts of stipendiary nurses are sanctioned to be filled on contract basis. The duties and responsibility of the permanent the duties and responsibility of permanent staff nurses as well as stipendiary staff nurses are one and the same in this institute. Institute does not allocate a separate work to a contract employee. In other words, first thing, I have, even according to them, I am discharging the duties of the post of staff nurses on par with a regular employee, except that the mode of payment is I am paid stipend instead of a regular salary. Then, my lord, it is respectfully submitted the appointment of it is respectfully submitted that the appointment of petitioners are against sanctioned vacancies of contract posts, and there is no provision to convert the contract posts to permanent posts and regularize them. Their consolidated pay will be enhanced from time to time. That is what they propose, my lord. That is, all those things are stated. So this reply statement I refer to for 2 things, my lord. One is that the posts are in existence. Secondly, that our appointment, the work and nature of duties of staff nurses which we are discharging in no way different from regular staff nurses, about 46 people who are regularly appointed. Therefore, keeping in view this, my lord, the court directed the regularization, page number 55. Page number 55, para 3, men. Para 2 and 3.
Yes.
Para 2, my lord, your Lordship got. Page number 55. The grievance of the petitioner is that petitioners are working as staff nurses in the Respondent 3 Institute. In this regard, petitioner approached the Respondent 3 by way of representation seeking for regulation of their services in terms of the law declared by State of Karnataka and also the law declared by the court in WP number so connected petitions. Having taken note of the fact that the grievance and petitioner seeking regulation of the service has not been considered by the respondent, I am of the opinion that respondent shall consider the representation dated 19/4/22 and so on, and pass accordingly. Then they issued the impure endorsement, my lord, annexure G. Identical endorsement is issued to all the persons. Let us now examine my lord, this endorsement, whether reasons given there are sustainable for rejection of regularization. They refer to the High Court order representation and page number 58. First contention is C&R rules does not provide for regularization. This is a totally untenable defense because no rules provide for regularization. Then there is no post called secondary staff nurse in the C&R rules. In the absence of permanent and substantial post under the C&R rules, there cannot be regularization. This post, this is contrary to their own reply statement in the earlier batch of writ petitions where they have said there is a post. Then, my lord, the appointment of Srimati Rani PJ and others for contract were stipulated. Finance department granted permission to appoint contract only. Srimati so and so and so initially appointed in contract base of 6 months at the time of issued, not issued public notification. And for that, I have shown in an appointment notification that there was an advertisement which I have shown. That's why I refer to that, my lord. So, a contract employee cannot claim regularization. Then, my lord, they refer to Paraji Supreme Court judgment, very Supreme Court judgment which I have relied. They say one para of that judgment they want to rely upon and say that the appointment is not proper. Then, my lord, the endorsement has been issued rejecting our case, my lord. In fact, I issued a notice after that. Thereafter, my lord, the present writ petition is filed challenging the very endorsement. Now, come to the reply filed in the present writ petition, my lord, by the second.
What is Annex H? There's some resolution dated 14/11/2005, page 62. The Governing Council meeting held on 14/11/2005. The Governing Council unanimously resolved to regularize the services of stipendary staff nurse employees. What is this?
In which one, my lord?
Annexure H.
Annexure H. Annexure H, my lord. This is one of the appointment appointment order, my lord. I think Annexure H is an appointment order in respect of.
Please read the first paragraph.
Yeah, first paragraph. In the Governing Council meeting held on 14/11/2005, the Governing Council of this institute unanimously resolved to regularize the service of staff and stipend the staff nurses employees who are working on contract basis and to appoint in the regular pay scales by relaxing the contract basis and appoint them on regular pay scales by relaxing on. Accordingly, Srimati K.N. Sudha is appointed provisionally as staff.
Do you have a copy of this resolution 14/11/2005?
That I don't have. That they should have, because this is only to show, point out that one Srimati K.N. Sudha, who was also appointed as a staff nurse earlier, has been appointed in the regular pay scale from 2006, my lord.
All right.
For that, it has been produced. Kindly see my pleadings. Page number para 12, my lord, the other to show substance. The no question of similar employees being considered by the management is also incorrect, in as much as petitioners are here is producing annexure H in respect of one Srimati K.M. Sudha, who was appointed as a contract staff nurse and thereafter her services have been regularized. Therefore, they say that it cannot be done like that. They have done it. If whoever they want to do, they will do. But for these people, because they have come in a batch, they are not doing. That's all. That is why annexure H is an identical person who has been regularized in 2006. Then coming to the reply statement of the respondents, my lord, because I can point out even in the present reply statement also, there are things which are in my favor, my lord. Kindly see. In the reply statement, my lord, they have generally bylaws they have produced, which has annexure R2, my lord, bylaws. Annexure 2, my lord, bylaws at page number 22. But their definition of an employee of the institution has been done. Their own council bylaws say that is definition 2H, my lord, 2H. 2H. Employee means a person in service of the institute in any post and includes the academic staff. Therefore, they call me contract, they call me stipend, whatever nature. I am holding a post and I am serving the department. I come under the employee definition. Only thing is, by designating me as a stipendary person, my regular pay scale has been denied, and also right to be considered for regularization has been denied. And now one more provision I want to point out, page number 23, para 5, regarding temporary and permanent posts. Page number 23, para 5, regulation 5. Permanent and temporary posts. The posts created by the governing council in accordance with class 3 of sub so and so and rule 10 of the sub rule so and so and regulation of the institution may be either permanent or temporary as the government may specify from to time. Therefore, there are two categories of posts, temporary and permanent. But still the posts, both are the posts which are in the institution, and I am treated as an employee in 2H. Then probation, my lord, page number 24, para 6. Because though I have not been used the word probation in the appointment order, they say you are initially 2 years you are appointed. That can be traced to regulation 6 of the governing council, page number 24, unless otherwise decided by the appointing authority. In any case, every employee shall be on probation for a period of 2 years, provided such probation is not applicable in case of undergone probation, who has already undergone a probation in government service. Therefore, this 2 years was the initial period of just like probation, but all our appointment orders initially 2 years like that they have put. Thereafter, my lord, they continued exploiting, taking lesser pay, and even now they are saying, okay, I will give you this much of pay. So far as pay scale is concerned, Supreme Court has already held that pay scale on par equal pay equal for should be given. That itself is denied. That denial itself is injustice. Now to say that you are not going to be regularized is further injustice that is being caused.
Yes.
And one more thing, my lord, in the very same recruitment rules, page number 31, rule number 3, regarding appointment and addition to the sanctioned cadre, page number 31, para 13. Notwithstanding anything contained in these, a governing council may make appointments to posts other than those in the sanctioned cadre on such terms and conditions as it may decide in each case.
Yes.
Page number 31.
Yes.
Regulation 13, appointment to posts in addition to sanctioned cadre, notwithstanding anything contained these rules, governing council may make appointment to posts other than those sanctioned cadre in such terms and conditions as it may decide. So that using this, they gave the lesser pay scale to us. But for that, the fact all other conditions of Uma Devi may not I satisfy. Therefore I am entitled for regularization. Now come to one judgment which I have produced, my lord, similar cases where contract employees working in the university, my lord, were sought to be denied regularization. Then I have produced a judgment of division bench, my lord, in memo dated 24 November 2023, my lord. 24 November 2023, I have filed a memo along with a judgment, my lord. Division bench judgment following Uma Devi, my lord, in respect of similar employees working in the veterinary institution, university, that is Karnataka Veterinary Animal and Fishery University. Lordship got.
Yes. Yes,
The writ appeal number 1185 of 2021.
yes, ಹೇಳಿ.
The memo may not filed on 24 November 23.
Yes. ಹೇಳಿ.
In that my lord, para 5,
Yes. Yes.
Learned councils also representing the respondent submit that the response in were appointed by the appellant university against sanctioned post since its inception and are continue to work in non-teaching post till date. The ground now urged by the appellant university that it lacks competency to regulate the service of the respondent is wholly untenable, inviting the attention of the court to the order dated 12/8/17. University with respect to one's round submitted that said daily wage employee who had left services was called and reappointed with retrospective in terms of decision of the management dated also cannot act arbitrarily discriminating the respondent for giving extracted the work from them against sanctioned vacancies. My lord, I pause for a moment. There also one M. Malesh who was working as a daily wage employee who had left the university was called back and his services were regularized. Whereas in the present case, one Srimati K.N. Sudha who was working on contract basis has been regularized. That is also a discrimination. No? University cannot act arbitrarily discriminating the respondents for having extracted the work from against sanctioned vacancies. Though the respondents are having worked continuously for more than 10 years and fulfilled the conditions indicated in the judgment in Uma Devi's case, followed by GP Sarojama versus State. Appellant University denying the request of the respondent for regulation is wholly untenable. Hence, the learned counsel, para 6, having heard the counsel for the parties, perusing the material on record, we are of the considered opinion that the appellant university has appointed the respondents on basis of policy of appointment for non-teaching staff as sanctioned against vacant posts and have continued in employment for more than 10 years. The ground of challenge that no government department is arrayed as a party to proceedings or university lacks the competency to regularize the services of the respondent is not supported by any valid substantial material. The endorsement dated so issued by the appellant university is not based on said reasons. If any other employees like M. Maleshi could be reinstated in the university and same yardstick is applicable in other cases also, it cannot be cherry picked by the appellant university to suit the convenience in as much as its competency to regularize the service of its employees. Even if such financial approval is required, it is obligatory on the part of the university to get such approval from the concerned, and same cannot be raised as a ground to reject the representation or to challenge the order of the learned single judge, more particularly when no ground was taken in the proceedings. Hence, the arguments also. The Honorable Apex Court in Shivanara and Singh Naragar and others reported in 2018 has categorically held that the extracting the work and not regularizing the employees would be a form of exploitation from the hands of the state. It is apt to refer to para 7. When we consider the prevailing scenario, it is painful to note that decision in Uma Devi's case has not been properly understood and rather wrongly applied by various state governments. We have called for the data in the instant case to ensure as to how many employees were working on contract basis or ad hoc basis or daily wage basis in different states. We can take judicial notice and widely aforesaid practice is being continued. Though this court has emphasized that the incumbent should be appointed on regular basis as per rules, but new device of making appointment on contract basis has been adopted. Employment is offered on daily wage basis, exploitative terms. This situation was not envisaged by Uma Devi. The prime intendment of the decision was that employment process should be fair means and not by backdoor entry, and in the available pay scale. That spirit of Uma Devi has been ignored and conveniently overlooked by various state government and authorities. We regretfully make the observation that Uma Devi has not been implemented in its true spirit and has not been followed in its path, pith and substance. It is being used only as a tool for not regularizing the services of the incumbent. They are being continued in service without payment of due salary for which they are entitled on Article 14 and 16 and 34(1)(d) of the Constitution. If they have no constitutional as envisaged in Nakara's case, from the cradle to grave. In heydays of life, they are serving that is Nakara's case. There is a clear contravention of the constitutional provisions and aspiration of the downtrodden class. They do have equal rights, and to take them equal, they require protection and cannot be dealt with arbitrarily. The kind of treatment meted out is not only bad, but equally unconstitutional and is denial of rights. We have strike a balance to really implement ideology of Uma Devi. Thus, the time has come to stop situation where Uma Devi can be permitted to be flouted, whereas this court has interdicted such employment way back in 2006. The employment cannot be on exploitative terms, whereas Uma Devi laid down that there cannot be a backdoor entry and every post should be filled by. But a new device has been adopted by making appointment on paltry system, on contract, ad hoc or otherwise. This kind of action is not permissible when we consider the pith and substance of Uma Devi. And Chandramohan case also referred has considered the schemes notified by the government where there was a condition that such appointees should not seek regularization. Having considered the services extended from time to time, they are also extended from time to time in view of the requirement of the state, and all appointed teachers having completed more than 15 years of service, the Apex Court directed regulation of such teachers. In the light of the judgment, the action of the appellant university in extracting the work from respondent for more than 10 years, appointing them on contract basis for smooth functioning and thereafter denying them regularization is wholly untenable. These aspects are extensively analyzed by the learned single judge arriving at a conclusion. What is relevant for the appellant university to examine the case of respondents in the light of the judgment, and having analyzed these aspects in the backdrop of the case narrated here in above, learned single judge has rightly held the endorsements on so university wholly and we find no jurisdiction. So in the instant case also, what is to be noted is they are being paid paltry sum and they have been denied regularization. And there it's also a case of discrimination as much as one Srimati Sudha, who was working as a contract employee, has been regularized, but given all the pay scale. And we are also asking for similar treatment, having regard 30 years, 2006 or 18 years.
Yes.
Therefore, I am requesting the court to consider two aspects, my lord. One is equal pay for equal work, my lord, and another is for regularization. Page number 16, para 2, my lord. To quash the endorsement is the first prayer. Second prayer is writ order or direction to regularize the service of the petitioner on the date they completed 10 years of service from the date of initial appointment and extend to them all the consequential benefits, including the pay scale attached to the post of staff nurse as they are discharging the duties of staff nurse, and to extend all the money.
Yes.
That's all.
Yes.
I'm appearing for the second respondent counsel, my lord. The point for your lordship consideration is the government has to, they have filed the objections and affidavit also before the honorable court. So Lordship kindly appreciate the point for consideration in this is whether the present petitioners are the contractual or a temporary employees or not. Whether they are come under the purview of the parameters or the guidelines laid down by the Uma Devi's case is the second point for it. The third point, my lord, here, by way of assisting your lordship, you have placed a material to show, recent material that is on, anyway, one more set I will give for the your lordship kind consideration. Anyway, are they available? In fact, the point in the for consideration is in that detailed memo, the number of the total appointments, your Lashmi kindly appreciate, the total sanction post is 200 and only the copy of it. 1 minute, sorry, madam.
25.
Extra. That has been to assist the honorable court, we have placed that record. Here, whatever the decision cited by my learned friend, is only in the sanctioned vacant post. Now, so far in this case, I'll point out from their own, originally the appointment in 2004, that is the first appointment order. So, Lashmi, along with my objection statement, annexure R1, so Lashmi kindly appreciate the same, the first petitioner, B.J. Rani, that has been reappointed. Your Lashmi kindly, that has been, whether they are the interpretation of whether they are the contractual or temporary employees. I point out from the annexure R1, may I request my lord to for a kindly, that is dated 25 January 2006. Here, the appointment for the post of trainee, you will ask me kindly the word used here. The appointment of the subject, appointment of the post of the trainee, secondary staff nurse in Jaideva Institute of Cardiology, Bangalore. B.J. Rani is appointed provisionally for 11 months. You will ask me the first appointment, as per my learned friend point out from his own petition, that is at page 119, what now he pointed out. Here, after that is dated 16/10/2004. You will ask me annexure R1 is dated 25/1/2006. He has been appointed for a 5,000 rupees on a stipend of rupees 5,000 per month, subject to the following conditions. He should report to the duty and assist to 2,000. Now here, my lord, what I try to point out here is whether they are the contractual, whether the appointment is not continuously for a period of 10 years. Here, they are only the, how he has been temporarily or a contractual basis of whether the.
Is there a contract entered?
As on the date of the appointment, they are fully aware of the fact that, my lord.
Is there a contract that you entered into? Is there a separate contract that you entered into with them?
There is a, in fact, as per the, I will verify this so far she has executed an agreement, that is what I want
But
to
the
say.
agreement is only to serve the institute for 11
Yes.
months.
Whether
That is not a
there
contract.
is a separate contract as such or not. In fact, so far they have been appointed.
Which is the provision under your C&R rules, which
Well, I
permit.
kindly appreciate. They have been appointed for a specific term.
Correct.
You are like what I tried to
Under which-
point out.
Under which rule of the C&R rules?
Yes, your Lordship, kindly, I'll try to point out we are governed by the bylaws. Number one, we have the C&R rules also. Your Lordship, kindly, what the C&R rules provide for it is, your Lordship, kindly permanent and temporary post. That is the C&R rules provide for it only. R3, annexure R3.
Yes.
R3, that along with our objection statement, you will have to make, that is annexure R3. Page number 30. Permanent and temporary post, class 10, my lord. The post created by the governing council in accordance with the class 2, subclass 27 of the memorandum of association and rule 10, subrule 4, subclass G, rule 18 and 19 rules and regulations of the institute may be either permanent or temporary as the governing council may specify times.
What is this clause 2, subclause 27 of the memorandum of association and rules 10? The rules 10.
Rule 10, that is a permanent and temporary. Here, my lord, whatever the decision, whatever may be the appointment, that has to go, that has to be approved by the governing council. Governing council is the supreme body, so far the institution is concerned. Here, the chief minister is the chairman of the governing council, and the director and the medical education secretary, they are all they are the members of the governing council. Ultimately, decision-making body is the governing council. You will ask me here, so far the appointing authority, as they have been appointed only as for a limited term. I do agree, they have served the institution, and because of the persuasion of this honorable court in subsequent order, the part of the record, the institution has persuaded the government to kindly consider that so far the pay is concerned. The institution at their own resources, whatever the resources, that is a fund, and they ultimately they decided to the salary of so much, that is 40,000, and we place the part of the record, and the concurrence of the finance department is
What
given.
is the salary of a permanent nurse?
Pardon me?
What is the salary of a permanent nurse?
That is exactly now. In fact, if your lordship or to the ultimately the government, ultimately government is the governing council is headed by a chief minister. Ultimately, finance department is the state is the sole custodian of the so far the finance and the thing is concerned. If they are agreeable, we have nothing to. In fact, we will certainly consider their appointment for regularization. And ultimately, the financial implications here, my lord, the 222, they are the sanction post only. all are working now. 800 are the stipend and all the institutions. Whether it is how long, my lord? In fact, I can understand the difficulty. That's why your lordship has entire institution, all 800 employees are now benefited by virtue of this order, by virtue of the your lordship's direction.
But by virtue of this order, they continue to be temporary
Yes, I do agree.
for
But
20
the-
years.
Your lordship as an institution, ultimately decision
but
making
ಇಪ್ಪತ್ತು
with the
ವರ್ಷ-
governing council. Ultimately decision in making is the government.
ಆದ್ರೂ 20 ವರ್ಷ ಟೆಂಪ್ರರಿ ಅನ್ನೋದು
ಅಲ್ಲ, ನಾನು 2004, 2006 ಒಂದು what the parameter your lordship may kindly appreciate. I do agree, we have a concern with the so far the cause of the grievance of the petitioner is concerned. But the point for your lordship consideration, ultimately this position of the facts and circumstances of the regularization is background. All the earlier judgments and all the referred judgments, you may request, my lord, the paragraph 34 of the only limited portion, wherever I'm need not going to trouble all the paragraphs. Only limit the paragraph 34 may be kindly be seen. In the same constitution bench judgment of the Supreme Court in a matter relating to 34 may be kindly be seen. Here, my lord, what I try to impress upon this court is, why try to pursue? There are your lordship, we are there to undergo certain procedure and a certain rule as far appointment is concerned. I do agree they are being due weightage to be given. I am fairly conceding. So far, because of their recognizing their service, due weightage to be given for even a fresh assuming if the government agrees, accepts, as your lordship what pointed out, the financial implication that has to be examined by the government. If the sanctions report, certainly the institution is ultimately the governing council is the appointing authority. If the sanctions report, so much of course you are to be called, and there will be certainly the priority to be given to the due weightage to be given. Certainly the institution is going, because ultimately the point is, ultimately, my lord, suppose, assuming for an argument's sake, if your lordship should direct, what ultimately it is opening the floodgate throughout all the medical colleges, all the medical institutions, that nearly so.
ಹಂಗೆ ಬಿಟ್ಬಿಡೋದು ಅಂತೀರಾ? They continuous.
That's why this is in a rarest rare case, because of the feelings of this court has been conveyed to the director and to the finance department to examine ultimately they enhance the salary.
ಇಲ್ಲ 1000 ನರ್ಸ್ಗಳು ಇದಾರೆ, ಅದ್ರಲ್ಲಿ 250 ಪರ್ಮನೆಂಟ್, 900
Contractual.
So virtually 4 times the permanent staff are
what
and you want the same status quo to continue. Virtually Jayadeva will be being run only by temporary nurses.
Oh, there is a lot of implications on the financial implications on the government. Ultimately, there must be. I do agree that so far there's
what is regular salary that
regular employees you present salary on 10,000, 5,000 varies. Just a bit.
At the time, in 2006, it was 4,575-8,400, page number 62. As early in 2006 itself, the pay scale was
Your lordship can,
4,575.
your lordship can take a judicial notice of it.
Now
fact,
it is
1 minute. You take a judicial, in number of here, my lord, the entire government as a whole. I am fairly, this is to assist your lordship, whatever the questions you arise. The manpower agency and the security, here the government, even including our own institution, the High Court. In fact, the computer operators, for your lordship, in fact, our own agency has been participated in the throat in Karnataka, nearly 15,000 employees, 10,000, 15,000, 20,000, they're all contractual. There is no permanent appointment as such. That is the position of the government. In recent days, there is no permanent, even drivers, even for staff, whatever it may be, their skill. And the appointment itself is a contractual one.
what is the solution?
The ultimate is a larger issue.
Is to continue the same thing forever.
Ultimately, the government has to say. Ultimately, the government must evolve a policy.
The institution has no objection if the government regularizes them.
Ultimately, if the sanctions report, certainly institution will consider.
Then how did the institute appoint these people? On what basis did they appoint?
The appointment is the only temporary one,
So,
and not against the sanction put. Whatever my learned friend has referred the division bench judgment of the Dharwad bench is concerned, in that case, there is against the sanction post, vacant post.
The-
Sanction vacant post.
in the earlier writ petition, you have agreed that it is a
No,
sanction.
no, no,
post.
you will ask me kindly see my endorsement.
They're working on the, no, endorsement relay.
No, no, you may request my lord kindly for a minute for an endorsement.
Now, kindly
Yes.
see the objection that you had filed in the earlier writ petition.
Earlier it petition has been filed by the government.
Page 45, my lord.
Please come to Annexure E, filed by the very same petitioners. At paragraph 4.
You will ask me kindly appreciate.
Page
that
45.
Para 3, what you will ask me pointed out.
Yes.
The stipendary appointments of petitioners are not against the sanction of a stipendary staff nurses. The word stipend, that means a fixed amount
Correct, ಅಲ್ಲ,
in a
stipend,
contract,
stipend ಕೊಡೋದು apprentice ಗಳಿಗೆ, 1 ವರ್ಷ, 2 ವರ್ಷ.
one amount.
25 ವರ್ಷ ಆದ್ರೂ stipend.
Now, it is very.
Para 4, you say, look at
Can
para 4.
understand the.
It is submitted that.
ನಮ್ಮ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ನಾವು ನೋಡ್ಬೋದು.
ಅಲ್ಲ, ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಬರಕಿನ ಮುಂಚೆ para 4 ಓದಿ ಕೌಂಟರ್ ಅಲ್ಲಿ. 565 posts of stipendary staff nurses are sanctioned to be filled on contract basis. The duties and responsibilities of these permanent staff nurses as well as the stipendary staff nurses are one and the same in
I
the six.
kindly appreciate, this is filed by the government. The government has to answer, ultimately, my lord, it is not an institution is filed.
No, the Department of Medical Education has said this, that they are the same. They said that it is a sanctioned post.
No, the.
What they are saying now is it is sanctioned contractual post.
Contract is, no, you,
The fact remains it is.
sanction post of stipendary nurses.
So this is not an irregular appointment. There is a paper
The
advertisement.
government taken.
There is a sanction to the contractual post. Therefore, there is no illegality in the mode of appointment. And the services extracted from them are the same as that of permanent staff nurse. But you are paying them probably less salary than the permanent staff nurses.
Dear my lord, ultimately, whether their appointment is in conformity to CNR rules or bylaws provide for it. Ultimately, my lord, in the government has filed the objection, I do agree with your lordship to the para 3 of the statement filed by the government. They have been appointed as against the sanction, the contract stipendary staff, I do agree. The government had to answer, if there is, I do agree so for that position of the paragraph.
Then what is this
But the point
resolution?
for your lordship.
What is the resolution that you have passed on 14/11/2005 referred to in this Annexure H?
Annexure H.
You have taken a decision to regularize the
Yes,
services.
it is a, it is the governing council, your lordship
You
here,
said
the highest body.
That was the highest body. If they have decided to regularize in respect of one set of employees in the year 2005,
This is a very, the one Sudha
you can make a discrimination.
that has been dated 27th January 2006.
I want a
That-
copy of this resolution, this 14/11/2005.
Proceedings of the finance committee, meeting held on, and the proceedings of the governing council, 14/11/2005. I'll try to place it before the court.
ಮಿಕ್ಕಿದೆಲ್ಲ ಗವರ್ಮೆಂಟ್ ಮೇಲೆ ಹಾಕ್ತೀರಾ ಅಷ್ಟೇ ಅಲ್ವಾ ನೀವು?
ಹೌದು. Ultimately, ನಮಗೆ we are not, in fact, once the chief minister is the governing, headed by the governing council, headed by him, for all decision, even including the, here, including all, even to extend the term of the director, continue the.
And I want the salaries that are paid to a regular staff nurse and the stipendary staff nurse. ಎಷ್ಟು
But
ಅಂತ
exactly the.
Memo affidavit or
ಅಫಿಡವಿಟ್ ಹಾಕಿದೀವಿ ನಾವು ಒಂದು ಯಾವತ್ತು ಅಂದ್ರೆ
ಇಲ್ಲ ಸಂಬಳ ಎಷ್ಟು ಅಂತ ಹಾಕಿ-
ಸಂಬಳ ನೋಡಿ ತಾವು 9th 11 may request your lordship kindly.
ಇಲ್ಲ ಇವ್ರಿಗೆ 40 ತಾಸು ರೂಪಾಯಿ ಮಾಡಿ ಅಂತ ಹಾಕಿ-
ನೋಡಿ existing consolidated pay, no, your lordship.
ಅಲ್ಲ, what is the regular salary of a permanent staff nurse? You have not stated.
Regular staff nurse ಅವ್ರು ಪರ್ಮನೆಂಟ್ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾರ, ಅದನ್ನ ನಾನು ಇಲ್ಲಿ ತಮ್ಮನ್ನ ಗಮನಿಸ್ತೀನಿ. ಮೇ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲಾರ್ಡ್.
ನೋಡಿದ
ಹೌದು, 56 ಇದು ಹೌದು. ಎನ್ಹಾನ್ಸ್ ಕನ್ಸಾಲಿಡೇಟ್ ಪೇ ಆಫ್ ಬಿಯಾಂಡ್ 15 years ಆದವರಿಗೆ ನಾವು ಅಪ್ ಟು 60,000 ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ದರ್ ಸರ್ವಿಸ್.
ಪರ್ಮನೆಂಟ್ ಸ್ಟಾಫ್ ನರ್ಸ್ ಎಷ್ಟು ಬೇಕು ಸಂಬಳ ಅಂತ
ಅದನ್ನೊಂದು ವಿಲ್ ಪ್ಲೇಸ್ ಇಟ್ ಬಿಫೋರ್. ನಿಮಗೆ ದಿ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಸೇ ದಿ ಲಾರ್ಜ್ ದಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಫಾರ್ to be.
You want to argue or you want to,
Your learned AG will appear on this matter. Your Lordship.
when?
Previous date of occasion, Bangalore appeared, your lordship. I seek 1 week time.
1 week ಕೊಡಲ್ಲ, Wednesday.
ಇಲ್ಲ ಇದರಲ್ಲಿ ತಾವು ಮೇ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ ಫಾರ್ ದಿ ಆಮೇಲೆ ದಿ ಕ್ವಶನ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಮೈ ಲಾರ್ಡ್ ವೆದರ್ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೊಸೀಜರ್ ಆಸ್ ಕಾಂಟೆಂಪ್ಲೇಟೆಡ್ ದಿ ರೋಸ್ಟರ್ ಇನ್ ಫ್ಯಾಕ್ಟ್ ನಾವು ಅದನ್ನ ಅಲ್ಟಿಮೇಟ್ಲಿ ವಿ ಆರ್ ಎವ್ರಿಥಿಂಗ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫಾಲೋಡ್ ದಿ ವಾಟ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ದಿ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಆರ್ ಗೈಡ್ಲೈನ್ಸ್ ಆರ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ so particularly paragraph 34 and may request my lord for a paragraph that has been party and the party 3 is very relevant here. Just for a few to assist your lord, your Lakshmi kindly appreciate paragraph 34. The referring the 3 judges bench of the made survey of authorities and held.
No, in the case of Uma Devi, they were considering daily wage employees.
Yes, exactly. Here also.
Where they did not go through a process of selection.
No.
Here, there was a walk-in interview pursuant to a paper publication. Because they were duly qualified, you selected them because of their qualification. So you cannot equate the case of Uma Devi with the case of this particular stipend to staff nurses. In the circumstance of that case where there was no procedure followed for recruiting, whatever the Supreme Court said may apply. But in a case where you conduct an interview, see that they're qualified, and then appoint them and retain them for 20 years. To say that roster is not followed or the process of recruitment is not followed, there is a process, right or wrong, that you followed by way of a walk-in interview. According to your own rules, that permits of temporary posts being appointed in a manner prescribed by the governing council. Governing council decided to hold a walk-in interview. Then
But
it's a regular
no,
recruitment.
basically only one clarification by way of assisting. Here, Uma Devi's case, the earlier there are judgments are referred. That has been earlier judgments of the apex court and the earlier.
No, in all
judgments of
those
the-
cases, they.
No, in all those, your lordship kindly appreciate whether the interpretation, what exactly, if an employee is continuously appointed for a period of 10 years, and if an appointment is not a contractual one, even if an employee is appointed for a specific term, as knowingly fully well is subjected to an appointment of a temporary or a limited period.
You were also aware that they had no right to continue after 11 months.
Definitely.
If you have not terminated services and you continued them for 20 years thereafterwards, now can you turn around and say that they.
We do agree ultimately, my lord, the government, if ultimately government frames a scheme and how this, do weightage to be given and to put an end for solution for ultimately for those who are the parameters for how many years they served and do weightage and.
You admit that they have not worked for more than 20 years. You don't dispute that fact.
We are, because the service is concerned, we admit, the manner, nature of service is different. The nature of service is.
Never said in your.
Break up with it. There is a.
It is not your case that the work that they do is lesser than that of a permanent staff nurse. Government also admits that.
Nature of work is.
The principle of same work, same pay.
The nature of work is concerned, your lordship is right, they are doing the same work and there is no differentiation as such. It is a.
Retrospective ಆಗಿ principle of same work, same pay ಆದ್ರೆ.
Ultimately.
ಸಂಬಳ ಜಾಸ್ತಿ ನೀವು.
ಹೌದು. Somewhere road, this is a social, ultimately government has to place some material.
Both of you don't appear to be ready. I think only I have to pass an order, right or wrong.
And now the question is the government has to examine that.
They will not examine because it's going to affect them financially. They are going to try to adjourn the matter endlessly.
The test of Uma Devi case to be.
That is why you said at least for the present I'll pay them 46,000.
Oh, because of.
So therefore you also realize that they cannot survive on the money that you are paying. They are required to serve your institution.
Let me kindly take a judicial notice of it. Here there is the very appointment, the meaning of government appointment is losing its sanctity. And all are being shifted to contractual appointments in all the departments as such. And when such being the case, it is a larger issue. And ultimately the government had to answer all these things.
Wednesday.
Obliged.
We have to confirm with them the salary
ಅದನ್ನ two
and
thousand five
and that resolution.
resolution.
My lord, I will produce the details of pay scale, my lord, as on today for the post, one thing. Secondly, my lord, I have given one order of appointment of one lady on regularizing. There are 6 people like that. Whoever government council wants, for them there is no government, no rule. They want, I will produce that.
Survey copy on them and then file it.
Yes, I will produce 6 orders of appointment in respect of others and also pay scale. Yes, yes.
For hearing B group, seal number 16, Shri Vivek Vada.
Correspondence in this case.
Yesterday's matter.
Yes, ma'am. No, there's one clarification in the memo. My learned friend had submitted that the bifurcation has been done. My lordship takes the memo at page number 32, document number 12.
Page number?
32, my lord.
Yes.
Document 12. There are 2 things, my lord. One is with respect to point number 1C, there is a note. Back billing charges of 18,62,235. So this approval was subject to payment of these back billing charges. This 18,62,235 back billing charges, which they have requested us to pay, is what has been impugned in this very writ petition. So it's admitted that this amount has not been paid. So the bifurcation has not happened. And subsequent thereto, my lord, at page number 35, pursuant to this, they have also issued another short demand notice. This we have sought to impugn by virtue, we filed an amended writ petition in the year 2018, and that has been challenged as well. So the question that fell from my lordships yesterday were whether from 2016 they can charge HT2B tariff in view that it's been bifurcated. That may not arise as the bifurcation itself has not happened.
So they're now claiming from July 2016.
Additionally, my lord, this is subsequent to the filing of the writ petition. During the pendency of...
But since you have sought for bifurcation, so from July 2016, you are bound to pay.
No, my lord, but they've not bifurcated it yet is my submission, my lord.
Now, what is the meaning of this? Was converted from HT2A to HT2B with effect from 29/6/2016 as per the OM dated so and so. On
Please,
this revised bill under H2B tariff from the month of July 16 to January 18, amounting to 1,76,000.
Please, my lord, my submission is that this conversion has not happened, which is why we've impugned this as well.
No, they have already said it is converted, right? So
My lord, the conversion was subject to us paying the back billing charges.
I look at that condition, but
Yes, ma'am.
from 2016, you have to pay. Even if I were to quash the back billing charges for the earlier period,
Please, ma'am.
from 2016, you are bound to pay.
My lord, that would arise only if they've bifurcated it.
They have bifurcated. I'll take this as a bifurcation order because they refer to this OM dated 29/6/2016, reference number 2 in that letter.
My lord, and also they've not specifically said that they've bifurcated it because we sought for bifurcation only with respect
Read
to
it once again.
25 kVA.
Read it once again.
Lots.
Was converted. They make that specific clarification. With reference to the above subject, as per your request, the installation bearing number so and so of Messer so and so was converted. Tariff from HT2A to HT2B1 with effect from 29/6/2016 as per OM issued by the EE under reference number 2. That is 29/6/2016. So you had made the request, that is granted. So from this particular date, you have to pay under HT2B. For the earlier period, I'll quash, saying that they could not do it.
Please, but my only submission is with respect to document number 12, which is at 16 June 2016.
No,
Is
I'll
that-
quash that in so far as it relates to the back billing charges.
Please, ma'am.
So from 2016, you will be liable to pay the charges.
Or that, let that question be kept open, my lord, because
You can't have it both ways, having sought for the conversion. How can you now go back and say?
no, my lord, the fact is that they've not converted it. Because till date, we have just 1 meter and
According to this OM, they say they have converted. So from 2009 to 2016, I'll protect you. From 2016, you'll have to pay. You have a copy of this OM dated 29/6/2016?
No, my lord. And my lord, this has been issued during the substances of this writ petition.
Therefore,
There was a stay order, and despite the stay order, they have passed this.
you did seek for conversion, that is granted. You can't go back now.
Please, ma'am.
So 2016 you pay. Earlier I'll protect you for the backdating charges. Yes.
Lords, my colleague who handles this matter is not keeping. Kindly request this court to have it on Tuesday. Please clarify on that one.
This is not fair. He had come yesterday.
Lords,
He did not come day before yesterday, so I adjourned it by one day. Now again, he argued yesterday, again.
Lords, in fact, take it as a submission, not keeping. Kindly have it on Tuesday. We'll assess the Tuesday.
If possible, get that OM dated
ma'am.
29/16.
Obliged.
Bill number 17, Shri Suresh Deshpande.
Hearing for respondent number 1, my lord, filed the memo for death report, the respondent number 1 in first case. And second case is respondent number 2.
With respect to respondent number 2 in 17.1 minutes, I have already filed an LR application
Filed wakalat.
that has not been put up. IA 1 of 23 was also allowed minutes on 7/9/2023.
Whose date you said?
My lord, the respondent number 1 in first case. And in WP number 7094 of 2012,
Petition.
the second respondent filed the memo for death report along with death certificate.
First objections.
In second case in petition number 1 is right.
Whose date? R1.
R1 Timrayappa.
When did he die?
My lord, 4/1/2024. And second case respondent number
Who
2.
died? Who else died?
Respondent number
Petitioner.
2 in the second case. ma'am.
Second case. Kallappa.
Second, respond number 2.
In the WP 7094 of 2011, same person.
7094 of 2012.
What is the challenge here?
We are challenging the order of the
MA.
Tahsildar. ma'am.
Tahsildar and district court in MA number 14 and
Where
grant.
re-grant.
Is Timrayappa again same?
Same.
Same. The petitioner had died in 17.1 and the LR application was filed and it was allowed minutes. The office note may be removed. IA 1 of 23. That was allowed already.
Kallappa.
In both the cases, you have not made the application to bring the LRs on record.
This we have filed, minutes. In the 17.1 we have filed, office has not put it up.
What is Timrayappa's role in the impugn order? Is he the
Sir,
beneficiary of the?
Please, ma'am.
Re-grant.
He is the beneficiary. He is the main beneficiary.
Will you take notice for the LRs?
First case, please. And second, first case in application ಹಾಕಿಲ್ಲ.
ಏನ್ ಬೇಕಿಲ್ಲ, ಒಂದ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ ಸಾಕಲ್ಲ.
Please.
ತರಿಸ್ತೀರ ಅಪ್ಲಿಕೇಶನ್ ಅದು?
ಹಾಕಿದೆ.
ಇಲ್ಲ ಹಾಕ್ಲಿ.
Second case.
Second case.
Petition filed by the LRs of Timrayappa to come on record is allowed. Delay ಇದೆಯಾ?
Delay ಇಲ್ಲ ma'am.
Delay ಇಲ್ಲ. Delay.
Caused to be amended. Shri.
3 ಅಪ್ಲಿಕೇಶನ್ ಸೇರಿ ಒಂದರಲ್ಲಿ ಹಾಕಿದ್ರೆ ಡಿಲೇ ಏನು ಬರಲ್ಲ.
ನೀವು ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ವಾ?
ಅಲ್ಲ ಅರ್ಲಿಯರ್ ಹಾಕಿದೀವಿ, ಈಗ ಹಾಕಿಲ್ಲ.
Shri L. Narasimhamurthy undertakes to file wakalat on behalf of the LRs of Timrayappa. When do you want it? Ready today?
No.
Any other?
2011, I can't grant you time.
Short date maybe. Any other day.
Will have it 26th or 27th.
On that date, please don't ask time, 2011 matter. List on.
20th.
20th. That's
20th.
Amend the cost rate right now, please.
Sir, 20th. Sir. 20th.
21st.
27th. 27th.
Seal number 18.
Your Lordship, I'm for petitioner in this case, my lord. Can you give a very short adjournment in this matter?
What is the matter about?
Yes. Your Lordship, actually my senior is not there right now, so can you give a very short adjournment, my lord?
It's 2014 matter, I can't grant you.
Very short date, next week, my lord.
What is the matter about?
Actually, senior is not here, my lord. Can you give a very short date, man?
Compensation. Who appears for the claimant? You appear.
I appear for 18.2, respondents 1 to 3.
Okay. Over ಹಾಕಿದಾರ? If you don't argue on the next occasion, I'll dispose of in your absence.
Yes, my lord. May I have it on next week, my lord?
21st.
21st.
Seal number 19. K. Vijay Kumar.
I appear for petitioner in one people are WP 14911. There are 3 writ petitions, my lord.
2015, please don't ask for time. India
14911. That all are connected. She may kindly.
And ಯಾರು ಒಬ್ಬರು ಮಾಡ್ರೆ ಸಾಕಲ್ಲ.
Next week we'll
Matter was adjourned on 29/2 from 29/2.
we'll cooperate for.
You are not cooperating. ಸುಮ್ನೆ cooperate ಅಂತ ಅಂದ್ರೆ.
Next occasion, we'll definitely.
ನೋಡೋಣ next time ನೋಡೋಣ.
ಮಾಡ್ತೀವಿ.
We'll list on.
21st.
21st.
Seal number 20. This party.
Manoj, in this case, I appear for response number 1, Manoj.
Lord, may I request for a week's accommodation? I'll get it. I'm sorry, my lord. 1 week.
We'll list.
21st.
Apply.
The mat, it has become infructuous, Manoj. That's the reason.
I'll take instructions on that.
Okay. Seal number 21. Srimati Vasundhara Pandit.
Lord, for respondent number 1, my lord.
Morning itself. It may be first 24th or 25th. I will see. I informed by the other side also.
27. 27.
27.
Seal number 22. Sri Surendra.
Senior correspondence queries. Lord, in this case, matter arising under the provisions of the Karnataka Excise Act. Lord, a foreign buyer places an order on the petitioner for supply of denatured spirit. Lord, the respondent, namely Karnataka State Beverages Corporation Limited, is the sole canalizing agent insofar as excisable goods are concerned. So any activity of trading must be channelized only through the respondent. Now, when the foreign buyer places an order on me for supply of denatured spirit, consequently, I bring it to the notice of the respondent, stating that here is an order placed on me, and for which, my lord, KSPCL places an order on me for me to supply, because I have to go through the entire channelizing through KSPCL. So in effect, what happens is KSPCL becomes the exporter, whereby the sales tax is exempt from payment of tax because of Section 5(1) of the Central Sales Tax Act 1956. My sale to KSPCL becomes a sale preceding the sale in the course of export, which is also exempt, subject to me producing a declaration in Form H. What happened was, originally when KSPCL filed their returns under the provisions of the VAT Act, they stated that this turnover is exempt from tax because we are direct exporters. Subsequently, they filed a revised return stating that we are not direct exporters. We are sellers preceding the sale in the course of export. When they took up that stand and when that matters were taken for assessment, the assessing authority rightly asked them to produce the declaration in Form H. They were not able to produce. They suffered an order. When they chose to carry the matter in appeal, questioning the correctness of that order, they sought for staying all further proceedings of recovery. The learned first appellate authority directed them to deposit certain monies because that was statutorily required to be deposited in order to be entitled for a stay order. They pay that money, take it out of the monies that I have parked with them as indemnity. For a folly of theirs, they chose to invoke the indemnity, take away my money, and the balance about nearly 2 crores, my lord, which is due to me for the payments of supplies made, they don't even make the payment. They say that in case we lose, we may have to take this money. Therefore, I am before your lordships questioning the correctness of the action of KSBC.
Which is the impugned order? Is there an impugned order here?
Lord, the impugned notice has been made a mention of in Annexure. Your lordship sees 69, my lord, Annexure J. Notice under section 9(2) of the CST Act, read with section so and so. Then if your lordship turns the page to 70,
This is the
notice which culminated in an order, and thereafter, my lord, they chose to file the appeal. The appeal got rejected, and they have filed a second appeal to the tribunal.
There is the order by which now the amount that is forfeited as against your,
Yes, my lord.
which is that annexure.
No, that came to be given to us much subsequent to filing of the writ petition, my lord. Because the first appeal filed by them came to be dismissed.
Now, what is your prayer?
My lord, my prayer is, if your lordships will kindly see, page 27. The petitioner most respectfully prays that this honorable court may be pleased to issue a direction directing the first respondent to refund the sum of rupees so-and-so pursuant to the invocation of the indemnity bond dated so-and-so, and further direct the first respondent to release the sum of rupees so-and-so, which is receivable by the petitioner.
Now, there is no formal order passed invoking the indemnity bond,
They have straight away done it because they've given me an annexure, your lordship sees.
which is that annexure.
Yes, ma'am. Page 72, Annexure K, your lordship kindly. It's addressed by the respondent to me. You had exported through us certain, the words through us is absent there, but it means that my lord, you had exported through us certain quantities of denatured so-and-so to one measure so-and-so Switzerland in the year 2013. In this regard, you had executed an indemnity bond dated so-and-so, wherein you had agreed to keep KSBCL indemnified in all respects due to the above export. Due to the above transaction, a demand of rupees so-and-so is raised on KSBCL by the commercial tax authorities, a copy of which is enclosed. KSBCL is preferring an appeal against the same. However, we need to deposit 30% of the demand amount, which amounts to so-and-so. Hence, your indemnity is hereby invoked, and an amount of so-and-so is deducted from the amounts payable by KSBCL to you, and the same will be deposited with the commercial tax authorities. Take note that if KSBCL is held liable to pay any further taxes and the appeal is not accepted, you will be required to indemnify KSBCL to
What is
that
the
extent.
indemnity that you had executed to them?
According to the circular, my lord, the circular your lordship sees gets it at Annexure B at page 35.
This indemnity dated 17/8/2013.
Lordship.
That is
It's
annexure.
at 65, my lord, the indemnity. Annexure F. Letter of indemnity dated 17/8/2013. Next page, your lordships will kindly see, my lord. The paragraph starting with the phrase, we state here that we have been appointed as agent for exporting, transporting the above consignment. We shall make necessary arrangement for export duly complying with all formalities and insurance coverage in respect of the above consignment at our cost and risk. So I offer the respondent this letter of indemnity. Now they invoke this, take away my money without even putting me on notice. And my lord, I must bring it to your lordship's kind notice. After having suffered an order at the hands of the first appellate authority, when they filed a second appeal to the tribunal, I have filed an application for intervention. Because if they don't argue the case appropriately, I lose the money. I have filed an application and the application is allowed,
The second appeal is not yet decided.
not yet disposed of.
Lords, if I may say. Lords, preliminarily, this issue emanates from the export transaction. Now, as per the transaction, what sir has told, we had shown us deemed export in our returns, fair enough. And there was a onus on the
Principal doubt that I have is,
my lords.
the indemnity that they had executed is for the loss or damage that you suffer.
No, I'll just come to that, my lords. Just kind of 2 minutes, my lords. My lords, they had to give us Form H, based on which we had to, because that we had to go and submit it to the department, because that is also a leg of the export transaction that is also exempted. Now, in amidst all these things, my lords, the case is pending before the CAT. STA that is pending before the CAT, and they have, in fact, we have in our letter told, you please come there so that the matter can be decided. That is point number 1. Now, point number 2, well, these are transactions which are contractual in nature. My preliminary objection is only this much. I'll come to the merits of the case. Preliminary objection of my objection is para number of the sourcing policy. There's an arbitration clause. Now, what has happened is, if this matter gets decided here, then in effect, my appeal gets infectious.
No.
Because, 1 minute, I'll just finish it off. The reason is, my lords, there is a transaction which has happened. The nitty-gritties needs to be seen. That needs to be ascertained by the court, and they need to give a judgment on that. Now, based on ultimately, my lords, if I may state, ultimately, no one will lose out of this transaction because it's a revenue neutral transaction. Whether I get the money or he get the money, we will have to get the refund from the government of Karnataka. Though this being the case, preliminarily, my objection is coming in a writ petition, seeking for this remedy at this point of time is not correct, because my appeal is pending there. We can as well go and argue before that. Then we can come to the second aspects of it. Now, coming to the merits of the case, my lords, kindly come to page number 43.
Maybe if you had listened to my doubt, then you would have understand what is running.
Yes, my lords.
This indemnity bond that is executed by them relates to any loss, damages, cost, charges and expenses which the corporation may suffer. They have not undertaken to indemnify you of any tax liability that you may incur.
My lords,
as a result of this transaction, you may suffer, you may not suffer a tax liability. A tax liability, can you bring it within the ambit of a loss or a damage to you?
lords, page number 43.
Of this contract to supply this denatured spirit. If you suffer any loss by virtue of the contract, is one thing. But if you suffer a tax liability, can you call that as a loss?
The tax liability suffered may be because of their transaction, because of their inability.
Been diligent when you entered into this contract. You should have told them in the indemnity bond, if there's any tax liability that occurs out of this particular transaction, you will be liable, not us.
My lords, I'll just tell them.
That is one thing.
I will come to that, my lords.
Where have you excluded yourself from this?
We have not excluded any tax liability anywhere. In fact,
Will suffer the
no, 1 minute, my lords. Page number 43, my lords. It is a fact that any export or any routing of the liquor has to be.
I'm not on that at all. Do you protect yourself from any tax liability by virtue of this?
I'll come to that, my lords. I am coming to that, my lords. Para number 16, indemnity. The manufacturer supplier shall keep the corporation harmless and indemnified in all matters arising from the supply of spirit to the corporation and its subsequent disposal.
This, how can you relate this to your tax liability?
Because
if as a result of any damages that you may occur because of a dispute between the purchaser and this gentleman.
No.
Then you will be entitled to.
No, my lords.
Not tax liability.
The issue is between me and the petitioner with respect to the very transaction itself.
The transaction was supply of this.
Two francs.
Now, suppose that gentleman says, I have not got this spirit.
No, that's not the issue. The issue here is, I had to supply the goods to him and he had to actually supply the goods to Colmar. Now, in this
You say it was the reverse.
No, the purchase order is with the Colmar. I do not have the purchase order. The reason is, the excise policy says everything has to be routed through.
In whose name did the export occur?
My lords?
In whose name did the export occur?
So it happened in their name.
May I explain?
My lords, page number 67.
Colmar is a foreign buyer.
Page number 67, my lords.
Foreign buyer places an order on the petitioner. because of the excise policy prevailing in our state, which calls upon me to channelize everything through the first respondent, what I do is I forward the contract of purchase from Colmar to me to KSBCL. KSBCL then calls upon the excise commissioner to allow for transportation of liquor from my unit to first respondent. But I undertake the act of export on behalf of KSBCL.
Where do you get that?
Yes, ma'am. That's available if your lordship.
The export is by you.
Yes.
Then why did they file a return saying that it is an export made by them?
No, that they filed the return.
We rectified it.
Originally, when they filed the correct return saying that they are the exporters. What they did subsequently by filing a revised return, which is an error, they said, we are not the exporter, we are a seller preceding the sale in the course of export, which is also exempt, but they ought not to have said that because I become a seller selling preceding the export. So my sale to KSBCL becomes a sale preceding, just prior to the export sale, which is also exempt subject to me producing H form. And KSBCL sale to Colmar, namely Switzerland, is the actual direct export, which is in any case exempt under section 5(1) of the CST
Have
Act.
that form that you have to give to them. Do you have that form?
Yes, ma'am. Your lordships will kindly see the tax invoice.
Is that form produced before the appellate authority?
No, that is insofar as my exemptions are concerned, they have been given to me.
No.
They did not choose to file the H form, therefore
No,
they ran a liability.
Who's to give the H form?
They have to
I
give
don't
me.
have to give it at all because it's a direct export.
No,
I can give one minute. Let me explain the problem.
I will just clarify.
In CST Act, what happens is, if there is an exporter, let us assume for the argument's sake, KSBCL is the actual exporter. When he does not have those goods, but instead he sources it from me. So my sale to him is a local sale. His sale is an export sale. His sale is exempt under section 5(1) of the CST Act because it's a direct export sale. My sale to him is a sale preceding the sale in the course of export, which is also exempt, subject to he furnishing an H form in my case. I have filed my return, I have got my exemption. When they filed their return, the original return was a correct return, which they said they are the direct exporters. I don't know what made them to amend that return. They filed a revised return. When they chose to file the revised return, the stand taken by them is, we are sellers preceding the actual export. Then the officer rightly asked them, if you are a seller preceding the sale in the course of export, please produce the H form. They did not have the H form. Therefore, the assessing authority was right in proceeding against them by creating a liability. Now, why should I give them H form? Because I am the person who is a recipient of H form. He is the exporter. If your lordships will see the tax invoice raised by me on KSBCL, page 67, Annexure G.
Suppose they have to withdraw that revised form. What would happen?
Then the original return stands subject to period of limitation applying. There are judgments which say, notwithstanding you having filed a revised return erroneously, if you are able to demonstrate by production of other evidences to say yours is an actual export, it will be treated as an export. It's in any case a revenue neutral as far as the state is concerned. State doesn't lose any money at all because in both the acts of export, whether direct or indirect export, state gets zero rated tax. But they have to make out that case, which they did not, which is why they suffered an order from the hands of the first
precisely before the, that is precisely before the tribunal. Now,
Then I'll go by this indemnity one because I don't see yourself insulated by any tax liability.
no, my lords, I'll come that to months. Page number 67, my lords. Page number 67, my lords, the order they have billed, this is a tax invoice which is billed to Colmar, and they say consignee is KSBCL delivery to France.
The letter that you have given to them is on the basis of the indemnity bond.
Fair enough, my lords.
In the indemnity bond, if you have not insulated yourself from any tax liability, whether it's on the basis of the original return or the revised
That
return.
includes everything, my lords. Because of page number, I'm just coming to the page number 65. My lords, pay all the losses, damages, cost. This para includes everything.
No.
My lords, this order, suppose if it's allowed, my lords, it will have a bearing on the tribunal's order now, because these are all facts which needs to be decided by the tribunal. Because this very instance has
is only against this particular order, communication 25/11/2016. You are saying
that because you have a right under the indemnity bond, you are invoking that component
No,
of,
not because of that. There's an order, my lords.
please read page 72. This is what that you say, this is what you say.
No, my lords, in the same paragraph, my lords, we have also told them.
That is
As-
what
No,
you
the reason, my lord, says, I am coming to page number 70, my lords.
may have a lot of reasons. Please read 72 once again.
I read, my lords, I am reading this. Hence, your indemnity is hereby invoked and an amount of 56 lakhs is
Please
deducted
read the
from.
paragraph preceding that.
Due to the above transaction, a demand of 186,92,460 is raised on case BCL by the commercial tax authorities, copy of which is enclosed.
So,
Case,
so this is not a loss for the transaction. This is a tax liability which arose because of the transaction.
that very tax liability, we are questioning that I am not liable for that.
Do whatever you want.
No,
to
no,
do.
that is why that,
How can you invoke the indemnity bond?
but the reason is, my lords, page number 70, my lords. There's an order which has been, page number 70. Please kindly, my lords, page number 70, because of the order they have come here. It says,
Tax,
for,
the page number 70 is again a tax liability that is.
no, I'm just coming to that, my lord. The reason I'm telling you. Further, you have claimed exemption in respect of the deemed export at 25 crores against H forms. That's because I supplied to him, he supplied, and he is supposed to give me the H forms. If he doesn't give me the H form, I can't even give it to the authority.
Doesn't
That
operate
is
that
the
way.
issue. That criticality is to be decided by the court. Now, these are issues which cannot be asked in the writ petition is what I'm asking for. Because this is an issue which needs to be pending. The matter is pending before the tribunal.
You should have been careful when you got the indemnity bond. You should have said,
No,
any tax liability that arises out of this is yours as one, not
Lords, it
mine.
includes everything for that matter. Inside, para number 2 of page number 66, we shall make necessary arrangements for duly complying with all formalities and insurance coverage in this, including the duties.
Not regarding the tax liability.
No, my lord, that itself is contentious because I'm not liable to pay at all at the end of the day. Because of their issue, I have paid the duty, I have suffered a loss. My lords, and this paragraph, page number 66, my lords, kindly, just a minute, my lords. We further undertake to indemnify the corporation from the following. It includes everything. It excludes the corporation from any legal disputes that may arise between the supplier and the buyer.
Between
Where-
the supplier and the buyer.
That's
The indemnity is essentially to safeguard you, insulate you from many consequences of the contract between the purchaser and the supplier, not regarding your tax liability.
My lords, my submission, my lord, says.
In fact,
But
if
these
you
are issues, my lord, these are issues which are contractual in nature, and that too, these are technical issues. My lords, I just want to give 2 judgments where specifically they have told, my lords.
Continue at 2:30. I have a division bench, I'll take some time and then I'll come back. Number?
Serial number 29, my lord.
Serial number Tuesday.
If a petition in 29, short date may be given.
Serial number 26 may be taken up.
Serial number 26, I'm for petitioner, and I would explain.
20?
26.
My lords, I appear for respondent in serial number 26. We have not been served with the petition copy. my lord.
26.
Serial number 20,
Kindly take up on some other day.
serial number 25 may be taken up on 19th or 20th, my lords.
Lord, 58, my lord.
Serial number 51. 21st. Next week.
Lord, 50,
My lord, serial for 30.
Lord, 58, my lord, I have to file statement of objections 24.
The date don't know.
Please.
51. He will have been. AB.
So 32. 32, nane petitioner. Next week or on date.
21st.
Okay.
Serial number.
First. 21st ಕೊಡ್ತೀವಿ ನೀವು 27 28
The serial number.
So
Sir, serial number
44,
59.
44 on the serial 44.
ನಾವು ಒಂದಿಷ್ಟು ಪೇಜ್ ವೈಸ್ ಕರೆದು ಬಿಡ್ತೀನಿ ಪೇಜ್ 9 serial number 25 to 31
24.
28 serial number.
24 ನಾವು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀರಾ ಸರ್ವಣ
ಅವ್ರಿಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಸರ್ವ್ ಮಾಡ್ಬೇಕಿತ್ತು ಇವತ್ತು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಕವರ್ಡ್ ಬೈ ಡಿಸಿಷನ್ ಅಂತ ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ
21st
ಹಾ 28 ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್ ಸರ್ 28 ಇಲ್ಲ ಸರ್ ನನಗೆ ತುಂಬಾ ಪ್ರೆಷರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಎಷ್ಟು ದಿವಸದಿಂದ
ಸರ್ ಅದು ಬೇಡ ಸರ್ ಅದು ಯಾರಿಗೂ ಅಪಿಯರ್ ಇರೋ ಕೇಳಿದಾರ
ಹೌದು
29, sir.
29 21st
21st.
59, sir, serial.
Page number 11, seal number 38 to 44.
44. Petitioner ಗೆ ಅದಕ್ಕೆ ಇಂಟ್ರಿ ಮಾಡಿರೋದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು.
21st.
ಸರ್ ಡೇಟ್
21st.
ಸರ್ 30 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
59
30 ಆಗಿದೆ ಸರ್.
ಆಗಿದೆಯಾ?
serial number 59 page number 40
Serial number
59
ಸಾಹೇಬ್ರು ಬೇಡ ಅಂದಿದ್ರು.
Sir, 71.
Respondent.
ನಾನು ಪಿಟಿಷನರ್ ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳಿದೆ.
21st.
ಐವೋ ಇದೆ
Sir, 71.
Next week ಬೇಡ, ಅದ್ರ next week ಯಾವ್ದಾರ ಡೇಟ್
60.
26, 27, 28.
27. Sorry, 28.
ಆಯ್ತು. 58.
ಸರ್ 54 ಒಂದು ಡೇಟ್ ಹೋಗಿದೆ ಅಂತ ನೋಡಿ.
54 ಇದೆ ಸರ್.
ಇದೆಯಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್
Sir, 71.
ಅವ್ರಿಗೆ ಹೇಳ್ತೀರಾ?
ಹೇಳ್ತೀನಿ ರಮೇಶ್ ಸರ್.
21st.
71.
58.
70.
1
21st.
Division bench adjournment.
Next week, any.
28.
47 ಒಂದಿದೆ, ಬರ್ತೀನಿ.
58. 27th ಇಲ್ಲ 28.
Any petitioner? Sir,
Respondent.
ಅವ್ರು ಯಾರಿಗೂ appearance date time ಕೊಡಿ. 28 ತಾನೆ?
58. 58. ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು.
21 ಅಲ್ಲ?
27.
ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಇದೆಯಾ?
ನಂಬರ್ ಫೋನ್ ಮಾಡ್ತಾ ಇದೀನಿ, ನಾಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
28.
ಸರ್ 38 ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 38.
ಸರ್ ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಪಿಟಿಷನರ್
ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ
ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡ್ರೆ
ಆಯ್ತು. 24
ಹಾ.
ಸರಿ ಸರ್. ಇನ್ನೊಂದು 73 ಅದು ಒಂದಿರಬೇಕು.
38. 21st.
21st ಅದು ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಇದೆ
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಹಾ ಸರಿ. 70 ಒಂದೇ ಒಂದು ನಿಮಿಷ, ಸಾರಿ.
ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರ್
ಹಾ
ತಗೊಂಡ್ರೆ ಬೆಳಗ್ಗೆ.
ಸರಿ ಸರ್.
73.
ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್? ಇಲ್ಲ ಅಲ್ಲ?
ಬೆಂಚ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
17 ಲಾಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ಮೆಂಟ್.
ಯಾವುದು?
Okay, sir. Right.
ಅದೇ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್.
ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ನೀವು ಐಯನೇ ಹಾಕಿಲ್ಲ.
ಅವರು ಅಂಡರ್ಟೇಕ್ಸ್
ತಗೊಂಡ್ರು ಬಟ್ ಐಯೇ ಬೇಕಲ್ವ ಸರ್ ಅದು? ಅಲ್ಲ ಮಾಡಿ ನೀವು ಸುರೇಶ್ ದೇಶಪಾಂಡೆ ಅದ್ರಲ್ಲಿ ಮಾಡಿಸಿದೀವಿ, ಇದ್ರಲ್ಲೂ ಆಗ್ಬೇಕು ಅವ್ರೆ ಸೇಮ್.
Sir, division bench ಎಷ್ಟೊತ್ತಿರುತ್ತೆ? ಹೆಚ್ಚು ಕಮ್ಮಿ.
2:30.
ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ ಸಿಂಗಲ್ ಬರ್ತಾರೆ.
ಎರಡು ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಎರಡೇ matter.
ಅದಾದ್ಮೇಲೆ ಬರ್ತಾರೆ ಧಾರವಾಡದಿಂದ ಕಲಬುರಗಿ ಒಂದೊಂದು ಮ್ಯಾಟ್ರ್.
ಎಲ್ಲ 1 hour ಆಗುತ್ತಾ? ಹೆಚ್ಚು ಕಮ್ಮಿ.
ಅದೇನಾದ್ರು ಬೇಗ ಆಗೋದ್ರೆ
ಗೊತ್ತಿಲ್ಲ.
ಇದೆಲ್ಲ 5 ನಿಮಿಷ ಅಷ್ಟೇ.
38 47 ಅಲ್ಲಿ.
ಹೌದು ಅದು ಆಯ್ತು.
ನೀವಿನ ಸೆಕ್ಷನ್
ಯಾವುದು?
ಅದರಲ್ಲಿ
7 ಇದೆ.
ಪೆನಾಲ್ಟಿ ವಿ ಹ್ಯಾವ್ ಕಲೆಕ್ಟೆಡ್ ರಾಯಲ್ಟಿ ಮೇಲೆ. ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೋಗ್ತೀನಿ ಡೆಪಾಸಿಟ್ ಹೇಳಿದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ ಅಂತ.
ಕಳ್ಸಿ ನೀವೇ ಕೊಟ್ರಲ್ಲ.
ಪೆನಾಲ್ಟಿ ರಾಯಲ್ಟಿ ಇತ್ತು ಮೇಲೆ ಕಾಂಟ್ರಾಕ್ಟ್
ಬಂದ್ರೆ ಮೂರು ಇದೆ, 3 ಬರ್ಬೇಕು. 3 ಬಂದ್ರೆ ಒಟ್ಟಿಗೆ ಕರೀತೀವಿ.
ಪೆನಾಲ್ಟಿ ಇತ್ತು ನಮ್ಗಲ್ಲ. ರಾಯಲ್ಟಿ
Court officer?
ಫೋನ್ ಮಾಡಿ.
Court officer?
in terms of your instruction
Madam, ಹೇಳಿ.
collected from
Sir, 25 adjourn ಆಗಿದ್ಯಾ?
deposit to you.
ಏನಾಯ್ತು next?
ಅವರು ರೀಫಂಡ್ ಕೇಳ್ತಾರೆ.
ಅರ್ಜನ್ ಆಯ್ತು ಮೇಡಮ್.
ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ ಸರ್?
21st.
Thank you, sir.
Refund
What else, sir?
Hello. Court officer?
ಸರ್ ಹೇಳಿ ಸರ್.
ಧಾರವಾಡ ಬೆಂಚ್ ಕರೀತಾರಲ್ಲ ಫಸ್ಟ್?
ಬರ್ತಾರೆ ಸರ್, ಒಂದು ಬೆಂಚ್ ಇದೆ, ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
ಹೌದು.
Court officer, sir. Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
Sir, 230 files ಬಂದ sir.
ಸರ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ.
Okay sir. ಎಷ್ಟೊತ್ತಿಗೆ ನಾನು ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲಾಗಿನ್ ಮಾಡ್ತೀನಿ.
ಸರ್ ಬೆಂಚ್ಗೆ ಹೋಗಿದ್ದಾರೆ ಸಾಹೇಬ್ರು, ಅದು ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತಾರೆ ಸರ್.
Thank you sir.
ಫೈಲ್ಸ್ ಬಂದ್ರೆ ಅವಾಗಲೇ ಕರಿತೀನಿ. ಧಾರವಾಡದಿದೆ, ಕಲಬುರ್ಗಿದೆ, ಇದೆ, ಎರಡು
Please.
ಬೆಂಚ್.
Please sir, please. Thank you.
Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
ಫಸ್ಟ್ ಧಾರವಾಡ ಮಟ್ಟಿಗೆ ಕೊಡ್ತೀರಾ ಸರ್?
ಸಾಹೇಬ್ರು ಬೆಂಚ್ಗೆ ಹೋಗಿದ್ದಾರೆ, ಬೆಂಚ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ಮೇಲೆ ಕರಿತೀವಿ.
ಅಲ್ಲ ಫಸ್ಟ್ ಯಾವ್ದು ಧಾರವಾಡ ಮಟ್ಟಿಗೆ?
ಹೌದು.
On submission, madam, in serial number 61, my lord.
Yes. Adjourn ಆಗಿದೆ.
Short accommodation, madam.
ಆಗಿದೆ, adjourn ಆಗಿದೆ ಆಗ್ಲಿ.
Forward bench matters. Seal number 1, Shri S.L. Matti.
Serial number 4.
Number 1.
Thank you. Yes. Matti ಅವರೇ.
S.L. Matti.
Madam, what happened? Do you have any idea in this? Acquire ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ, ನಾನು ಆಯ್ತಾ?
Forward.
Release term. By that time, the government to state what are the steps that have been taken in terms of the order passed in this petition regarding acquisition of the lands.
Seal number 2, Shri Sachin Angadi.
You are appearing to VC, your lordship.
Yes.
Your lordship, the offense punishable under section, your lordship. Wildlife Protection Act, your lordship, section 9, 39, 40, 44, 2 subclass 36, 48, A, 49B, 50 and 51 of Wildlife Protection Act, your lordship. Your lordship, in this case, your lordship, range forest officer, mobile squad, Ballari, has registered the case against this petitioner, your lordship. This first, your lordship, page number 9, your lordship, annex A, your lordship, which is the FIR, FOC, your lordship. And your afterwards, your lordship, they are filed the private complaint before the magistrate, your lordship, which is page number 12, your annex B, your lordship. Your one side, your lordship.
You are the first accused.
Yes, sir, I am the first accused, your lordship. Co-accused is quashed by this honorable court, your lordship. And your lordship, I am not the owner of the that shop, your lordship. I am the advocate, your lordship. I am practicing advocate at Ballari, your lordship. I am nowhere consent of that shop, your lordship.
Who appears for the state?
Quashed, your lordship.
Like state guy, yara pirakhtara.
State ಗೆ ಗೊತ್ತು.
Who's the SPP there?
No, Lord, please. JCCP, no, there.
Get him and have it next Friday.
Your lordship, yes, sir. One covered by judgment also is there, your lordship. Range first. Yes, sir. Yes, sir.
ಬರ್ಬೇಕು ತಾನೆ ಅವರು?
Yes, your lordship. Kindly extend the interim order, your lordship.
Interim order extended.
Seal number 3, Shri Ravi Hegde.
Please, appearing for petitioner.
ಏನಾಯ್ತು, ಅಪೀಲ್ ಹಾಕಿದ್ರಾ?
ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. That is still in non-compliance office objection. ಅದು ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇದೆ.
Where is Prashant?
Prashant is not here, brother.
Why they're boycotting the court today or what? Nobody is coming on.
Morning is here, brother.
Next Friday.
Please.
For admission, seal number 4, Shri Patakurki.
The essential commodities are section 3 and 7. That fertilizer control order. That the present petitioner is the sales representative.
and he is not a compliance officer. And already my lords have bashed in respect of dealer my lord, that I have produced his identity card. And even in complaint, my lords, they have said some Williamson is a compliance officer.
Take out notice on the state. Who appears?
Please, please.
It's to take notice for respondent. Relist on.
21st. Seal number 5, Shri Anmar, T. Anmar Reddy.
Serial number 5 and 6 are connected, my lords. Serial number 5 is by the accused number 8, my lords. Serial number 6 is by the accused number 7. And then similarly situated, my lords, respect of accused number 6, my lords, kindly go to page number 151. 151. This judgment pertains to my lordships with respect of accused number 6. My lords, the offence alleged under section of the NDPS Act, based on the voluntary statement of the my lords accused number 1. This the name of this other accused persons came to be included in the my lords charge sheet. And there is a recovery as against the accused number 1 at the spot, my lords. And based on his confession statement, this name of all this other accused person came to be included in the charge sheet.
Take out notice on the state. You will take notice for respondents. Relist on.
Please. This date may be fixed.
Next week dispose Mahapadithin.
Please.
Seal number 6, Shri Vadi Raja.
Same. 5 and 6.
I appear.
Connected.
Serial number 5 and serial number 6 are connected. 6 and 7 are connected. 5 and 6 are connected. Sorry, 5 and 6 are connected.
For further hearing, seal number 7, Shri Sri Harsha Nilopan.
The petitioners had undertaken to deposit within 3 months. The KPID Act, since due to Lok Sabha election, they could not mobilize funds. Another 30 days, Lord, finally.
Please. The question of interest, my lord, has been kept open, please, my lord.
ನೀನ್ ಹೇಳಕ್ ಹೋಗಲ್ಲ ಸುಮ್ಮನೆ ಸದ್ಯಕ್ಕೆ ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ.
Please.
Then consider the business seats for 4 more weeks time to deposit the amount as agreed in the affidavit. Relist on.
4 weeks may be given, my lord. Though my elder brother is saying 2, 4 weeks may be given, my
4
lord.
weeks ಹೇಳಿದ್ವಿ.
Please.
5th July.
Oblige me.
For further consideration, seal number 8, Shri Ravi Hegde.
Please, I'm appearing for petitioner. Petitioner is before this court, my lord, seeking mandamus, directing the respondent number 2 to transfer the petitioner from Mahalakshmi First Grade College, Dharwad.
ಏನಾಯ್ತು ಇದರಲ್ಲಿ?
Tumkur. Please, my lord.
What happened?
ಏನು ಮಾಡಿಲ್ಲ ಅವರು. My lord, I have taken the hand summons on the administrator, who is appointed pursuant to the order of Honorable Apex Court. Annexure A is the compromise, my lord, para 6, page number 12, my lord, sir.
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಾ ಅವ್ರಿಗೆ ಯಾತ್ರಿಗೆ?
Notice serve ಆಗಿದೆ, hand summons ತಗೊಂಡಿದ್ದೀನಿ. I have filed the original hand summons before this honorable court along with memo.
AGA has appeared. R3 ಗೆ.
Last date of hearing, lordship has directed AGA to take notice for respondent number 3.
ಇಲ್ಲ, I did not order the, I think he himself has undertakes to appear ಅಂತ ಮಾಡಿದ್ದೆ. Where is he? Manju Bairal.
Please note.
Last time Manju Bairal had undertaken to enter appearance.
Yes.
ಇಲ್ವೋ ಅವರಲ್ಲಿ?
ಇಲ್ಲ ಅದು.
Next Friday ಬರಕ್ಕೆ ಹೇಳಿ ಅವ್ರಿಗೆ. Next Friday.
Please. May I request finally, Lord?
16 to.
Seal number 9, Shri Sangram S. Kulkarni.
Lord, I am for the petitioner, Lord.
It so happened, my lord, during the elections, my lord, there was some other administrative officer, my lord, because of the election transfer for 10 days. In fact, my lords, your lordships have taken a view, my lords, in WP number 19588 of 23 or 9th of May, my lords. So that may assist me, that may help me, my lords. I will resort on that judgment also, please, my lord. 2 weeks before, my lord, finally. 20, deeply obliged.
Kalburgi bench matters. For orders.
As requested, time sought for is extended. ಎಷ್ಟು ದಿನ ನೋಡ್ಕೊಂಡು ನಾವು
For further consideration, seal number 2. Shri Ganesh Subhash Chandra Kalburgi.
Realist.
21st. Bangalore bench matter.
Lord, I may invite my lord's kind attention to the indemnity clause in the policy at page 43. The lordship sees under what circumstances I ought to keep the corporation indemnified against. The lordships may kindly turn to page 43. Down below paragraph 16, indemnity. Lordship gets it, Miller? The manufacturing supply shall keep the corporation harmless and indemnified in all matters arising from supply spirit to the corporation and its subsequent disposal. Any third-party claims arising from any buyer shall be settled by the manufacturer supplier at his cost. More specifically, the manufacturer supplier shall indemnify the corporation to keep it harmless with respect to 1. Non-compliance with the policy of the corporation regulatory authorities. 2. Non-compliance with the standards specified by the regulatory authorities. 3. Non-conformation to the provisions of various laws in force and consequences, losses or claims, including claims of additional duty, taxes raised by the government of Karnataka, more specifically the non-remittance and short remittance towards duties, taxes statutorily payable. Quality claims that may arise, that may be raised by any user or the ultimate consumer of spirit. 5. Claims for damages that may be raised by any user or the ultimate consumer, etc. Now, the taxes that are spoken of here in clause 3 is with reference to the petitioner's non-payment towards the commercial taxes department. That can be sought to be recovered from the corporation. So I ought to keep the corporation indemnified from all taxes. So which means I must keep paying the taxes duly as and when they fall due.
Saying the default by you regarding payment of taxes.
Absolutely. That is because there are provisions under the commercial tax laws where garnishee notice can be issued to any other third party.
No, would it help solve the entire problem if I were to direct the second appellate authority to consider asking them to withdraw the modified revised assessment and consider the original assessment and then pass an order?
They will get the relief. But in the meanwhile, my lord, my money has been held by them and utilized, and subsequent money which is due to me in a sum of almost 2 crores is also being retained by them. That may be directed to be released, my lord.
No, that also I can do, but do you think it will be better if I ask the second appellate authority to decide the dispute first and then consider this?
But the matter is pending before the tribunal, unless your lordships were to set aside the order. But that nobody has challenged the order before your lordships.
My lords,
There will be a small difficulty there.
if I may submit, my lords.
No, this arises as a consequence of the proceedings there, isn't it?
Yes, my lords.
So can I not direct the appellate tribunal to consider disposing of the appeal in the light of the statement made by them?
Very good.
That they'll go by the original written and not by the revised written?
No. Yes, my lords, the
So that
reason.
will help you.
No, sir, my lords, my only submission is, they have also implemented in the appeal. And we have told that in the indemnity letter also. At the end of the day, my lords, whether I pay or they pay, ultimately it's a revenue neutral transaction. Ultimately, the government has to refund the money to us. There is a procedural lapse which has happened from both of us.
No,
It has happened.
Not from my side.
It is a matter
Not
which is
from my
now
Now, do you want a solution or do you want to pass an order saying that he is not liable to indemnify for your tax liability?
I will certainly initiate an order.
If you want to argue, I'll simply say that he is not able to indemnify you for the tax liability, therefore I'll quash this annexure. And the matter will come to an end, as far as he is concerned. You will again struggle there.
No, I would urge
But are you prepared to go by the original returns that you filed and
no,
not by
because
the-
because my lords, we have gone on appeal to the CAT.
Therefore, will you make a statement that you will?
I have to take instructions, my lords. I have to take instructions from, because my lords,
If you don't take that instruction and make that submission, I will proceed to hold in there.
no, my lords, my only submission is, my lords, the original order is against us.
The original order is on the basis of the revised assessment, isn't it?
Yes, my lords.
If you were to make a statement that you will go by the original assessment, the return that you filed, and not by the revised return,
Yes.
and direct the appellate tribunal to consider that matter and
Yes.
pass an order.
I will take instructions, my lords. Let me.
That way, at least all your problems could be
I
solved.
understand, my lords. I have to take instructions. It's a
You
government.
want to argue on technicalities, I'll also dispose on technicalities.
I'm not on that, my lords. I'm only telling I will take instructions. Let me take instructions and I will,
Tuesday, Wednesday,
Wednesday, my lords.
Wednesday.
But kindly see my lord, my 2 crores is
So
held
you
by
waited
them.
for 7 years. I think you can wait for 7 more
Very
years.
well, my lord. Grateful to your lordship. Wednesday at 2:30, my lord? 20th.
20th.
20th is what day?
Just see, much obliged.
Huh? 20th June. Okay. Grateful to your lordship.
Much obliged.
23 to 27 adjourned, seal number 28. CH-16. CH-16.
ಬೆಳಿಗ್ಗೆ ಬಂದಿದ್ರು.
ಮೇಡಮ್, ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬರಕ್ಕೆ ಹೇಳಿದ್ವಲ್ಲ,
ಬಂದಿದ್ರು ಬೆಳಿಗ್ಗೆ ಇಬ್ಬರು ಇದ್ರು ಇಲ್ಲಿ.
ಏನಂತ ಹೇಳಿದ್ರ? You taken instruction from him? ಕೇಳ್ಕೊಂಡಿದ್ದೀರಾ? ಅದು ಡಿಫೆಕ್ಟ್ ಸರ್ಟಿಫೈ ಮಾಡಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅವರು?
ನಾವು ಏನು ಅವರಿಗೆ ಒಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಹಾ.
ಈ ತರ ಡಿಫಿಷಿಯನ್ಸಿ ಇದೆ, ಇದನ್ನ ನೀವು ಕರೆಕ್ಟ್ ಮಾಡಿ.
ಅದ್ ಮಾಡಕ್ ಆಗುತ್ತಾ?
ಮಾಡ್ಬೋದು ಸರ್ ಅವರು. ಅದರಲ್ಲಿ ಕೆಲವು ಮಾಡಕ್ಕಾಗತ್ತೆ, ಕೆಲವು ಮಾಡಕ್ಕಾಗ್ತಾ ಇಲ್ಲ.
ಯಾವ್ದು ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ?
ಈಗ ಫಸ್ಟ್ ಅವರು ರಿವೈಸ್ಡ್ NOC ತಗೊಳ್ಬೇಕು ಸರ್.
ಯಾರ ಹತ್ರ?
ನಮ್ಮ ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ.
ನೀವು ರಿವರ್ಸ್ NOC ಕೊಡೋಕೆ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ಅವರು ವಾಟ್ ಟು ದೇ ಹ್ಯಾವ್ ಟು ಸ್ಯಾಟಿಸ್ಫೈ?
ಈಗ ಅವರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನದೇ ಇದ್ರ ಪ್ರಕಾರ ಮಾಡಿಲ್ಲ ಸರ್, ಏನು NOC ಪ್ರಕಾರ ಸ್ವಲ್ಪ ಆಲ್ಟರ್ ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡುವಾಗ. ಅದಕ್ಕೋಸ್ಕರ ಅವರು ರಿವೈಸ್ಡ್ ತಗೊಂಡು ಆ ನಂತರ ಏನಂತಂದ್ರೆ ಕ್ಲಿಯರೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ಸರ್.
ಇಲ್ಲ, ಕೆಲಸ ಆಗುತ್ತೋ ಆಗಲ್ವೋ? ನೀವು ಆಗ್ದಿರೋ ಕೆಲಸ ತಗೊಂಡ್ ಏನೋ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ ಅದು.
ಅದರಲ್ಲಿ ಏನಂದ್ರೆ ಒಂದು ಸೆಟ್ ಬ್ಯಾಕ್ದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸರ್. ಈಗ ಹೈಟ್ ಆಫ್ ದ ಬಿಲ್ಡಿಂಗ್ 33 ಇದೆ, ಅದಕ್ಕೆ ಓಪನ್ ಸ್ಪೇಸ್ ಏನಂದ್ರೆ 11 ಮೀಟರ್ಸ್ ಬೇಕು. ಬಟ್ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಮತ್ತು ವೆಸ್ಟರ್ನ್ ಸೈಡು ನಿಲ್ ಸರ್, ಅಲ್ಲಿ ಏನು ಓಪನ್ ಸ್ಪೇಸ್ ಇಲ್ಲ. ಸೊ ಅದು ಬಹಳ ಕಷ್ಟ ಆಗ್ಬೋದು ಅವರಿಗೆ.
ಹಂಗಾರೆ ನೀವು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡಲ್ಲ?
ಅದು ಕ್ಲಿಯರ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ ಸರ್, ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಕ್ಲಿಯರ್ ಮಾಡಕ್ ಆಗುತ್ತಾ ಆಗಲ್ವೋ ಅದನ್ನ ಕೇಳ್ತಿದ್ ನಿಮ್ಗೆ. ಆಗಲ್ಲ ಅಂತಂದ್ರೆ ನೀವು ಕೊಡಲ್ಲ.
ಹೌದು ಸರ್.
ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಬಿಲ್ಡಿಂಗ್ ಹೊಡೆದಾಕ್ಬೇಕು.
ಅಂದ್ರೆ ಮತ್ತೆ ರೆಡ್ಯೂಸ್ ಮಾಡು, ಹೈಟ್ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಸರ್.
ಹೆಂಗ್ ಮಾಡ್ತೀರಿ ಹೈಟ್ ರೆಡ್ಯೂಸ್ ಅಂದ್ರೆ?
ಹೊಡೆದಾಕ್ಬೇಕು ಸರ್, ಹೊಡೆದಾಕ್ಬೇಕು, ಚಾನ್ಸ್ ಇಲ್ಲ.
ಅದಕ್ಕೂ ನಿಮ್ ಫೈರ್ ಸೇಫ್ಟಿಗೂ ಏನ್ ಸಂಬಂಧ ಏನು?
ಬಟ್ ಅದು ಆಸ್ ಪರ್ NBC ಇಟ್ ಇಸ್ ದ ನಾರ್ಮ್ ಸರ್.
ಆಸ್ ಪರ್
NBC ಸರ್, ನ್ಯಾಷನಲ್ ಬಿಲ್ಡಿಂಗ್ ಕೋಡ್ ಪ್ರಕಾರ ಇಟ್ ಇಸ್ ಎ ನಾರ್ಮ್ಸ್. ಏನಂತ ಹೇಳಿದ್ರೆ
ಐ ವಾಸ್ ಅಂಡರ್ ದಿ ಇಂಪ್ರೆಷನ್ ದಟ್ ವಾಟ್ ಇಸ್ ಯುವರ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಫೈರ್ ಸೇಫ್ಟಿಗೆ ಏನೇನ್ ಬೇಕೋ ಅದು
ದಿಸ್ ಇಸ್
ನಿಮ್ಗೂ ಬಿಲ್ಡಿಂಗ್ ಕೋಡ್ಗೂ ಏನ್ ಸಂಬಂಧ?
ಬಟ್ ಆಸ್ ಪರ್ ದಿ NBC ನಾವು ರೆಕಮೆಂಡ್ ಮಾಡ್ತೀವಿ ಸರ್. ಈಗ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಈಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ನ್ಯಾಷನಲ್ ಬಿಲ್ಡಿಂಗ್ ಕೋಡ್ ಪ್ರಕಾರನೇ ಏನ್ ನಾರ್ಮ್ಸ್ ಇದೆ ಆ ಪ್ರಕಾರನೇ ಮಾಡ್ಬೇಕು.
ಏನಂದ್ರೆ ಆಗಲ್ಲ ಕೆಲಸ ಇದೆ?
ಇಲ್ಲ, ಈ ಸೆಟ್ ಬ್ಯಾಕ್ ಇದೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಬಟ್ ಅದರ್ ಫೈಟಿಂಗ್ಸ್ ಇನ್ನೂ ಮಾಡಲಿಲ್ಲ ಸರ್. ಬಟ್ ಅದೆಲ್ಲ ಇದೆ. ಏನಂತ ಹೇಳಿದ್ರೆ ಲೈಕ್ ವೆಟ್ರೈಸರ್, ಡೌನ್ ಕಮರ್ ಸಿಸ್ಟಮ್ಸ್, ಹೋಸ್ ರೀಲ್, ಆಮೇಲೆ ಡಿಟೆಕ್ಟರ್, ಸ್ಮೋಕ್ ಡಿಟೆಕ್ಟರ್ಸ್, ಇದೆಲ್ಲ ಇದೆ. ಇದೆಲ್ಲ ಮಾಡ್ಬೋದು ಅದು. ಬಟ್ ಇದು ಮೇನ್ ಇದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
ಕೊಡಿ ಅದೇನು?
These are the list of the defects.
No, is there a solution to the problem or no solution? If you were to ask them to demolish the entire apartment.
But as per the norms, they have to comply with the order, Your Lord.
Has OC been given to them, occupancy certificate ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. ಇನ್ನು ಅದು ಬಿಲ್ಡಿಂಗ್ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಒಂದ್ ಪೋರ್ಷನ್ ಕಮರ್ಷಿಯಲ್, ಒಂದ್ ಪೋರ್ಷನ್ ರೆಸಿಡೆನ್ಷಿಯಲ್. ಕಮರ್ಷಿಯಲ್ ಇಸ್ ನಾಟ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್, ಓನ್ಲಿ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಮಾತ್ರ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದೆ. 2014 ಅಲ್ಲೇ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾನೆ.
And without receiving occupancy certificates, they have occupied the flats, your lordship.
True. 90% of the houses in Bangalore are without OC.
Lordship?
90% of the structures in Bangalore are without occupancy certificate.
Yes, your lordship. And it is the responsibility of the owners to receive the occupancy certificate from the builders.
ಈ ತರದ ಬಿಲ್ಡಿಂಗ್ ಆ ಸಂದರ್ಭದಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್
And there is also gazette notification, your lordship. As per this, and this gazette notification has been passed as per the direction of the High Court. Kindly, page number 3, para 8, lordship. If occupier, developer, owner. Shall I read it, lordship?
Yes, taking.
And this notification is also done due to the writ petitions filed before the Honorable High Court. And as per the direction, this notification has been passed here.
What is the height of this building?
That is 33.20.
33.2 meters.
33.20.
Meters.
20 meters.
Meters.
Copy here. Copy.
And there are more than 228 apartments in the said apartment complex, your lordship.
What is the meaning of this Clause 3.
Notification, your lordship.
Yes.
So far as to the existing but occupied buildings and buildings under construction as concerned, the BBMP or local municipal authority shall not grant occupancy certificate unless until sufficient fire protection system is installed before the building is made operational and is certified by fire officer not below the rank of district fire officer and nominated by the Director General Fire and Emergency
So
Services.
the only requirement is that sufficient fire protection system is installed.
Yes, your lordship.
So long as that system is installed, whether this grant of NOC and other things are for new buildings,
New buildings.
occupied building, how is clause 3 to be interpreted?
Not to find out.
Now this building is occupied.
Yes, your lordship. Already
So
occupied.
all that is required to be done by the fire department is to ensure that the fire protection system is installed. So if that is satisfied, what should be the difficulty in granting power? I leave liberty to the BBMP to take action for the violation of the.
BBMP.
Your main concern is fire protection, isn't it? In the
Yes,
event of
sir.
a fire,
Yes.
you should ensure that there's adequate measures for repelling the fire. Building code though nimgo actually in sambandha illa. This is your notification, which only requires fire protection system to be installed.
Yes, sir.
Ashmadra Saka ಅವರು.
If the your lordship. Para 8, your lordship, if the occupier, developer, owner, builder has failed to intimate.
That is in with reference to the earlier paragraphs. During inspection, if they were to inspect and then find
Yes, your lordship.
deficiencies. What about clause 3?
Existing. Shall not grant. Unless and until sufficient fire protection system.
Para 3 is complemented by para 6.
The clause 1 also deals with the prior to the building, that is, should not grant building plans or licenses without obtaining NOC. Clause 2 is in high-rise buildings wherein safety measures are required to be provided under the building bylaws so and so, so and so.
In,
The builder so and so shall provide the fire safety measures. These are buildings yet to be constructed.
in this matter, they have already taken the NOC by the builders, your lordship. As per that NOC, they are not complied with the.
All right, but para 3 ultimately says that the BBMP cannot give OC until the fire protection system is installed.
Unless
So-
until sufficient fire protection system is installed.
So assuming everything else is also correct, even then the only requirement is fire protection system is to be available in the building.
Yes, your
If that is there, as far as the fire department is concerned, and the safety of the dwellers there is taken care of. Let the BBMP take action for the violation of the building code or for the violation of the building.
Yes, your lordship. BBMP building.
ಮಾಡ್ಬೋದಾ ಹಂಗೆ?
BBMP ಎಲ್ಲಿ ಬರುತ್ತೆ? BBMP ಕೇಳಿ. ಇಲ್ಲ.
ಆಗ್ಬೋದು, ಯಾಕಂದ್ರೆ ನಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
BBMP ಕೇಳಿ.
How much would it cost? ಅಲ್ಲಿ ಫೈರ್ ಸಿಸ್ಟಮ್ ಇನ್ಸ್ಟಾಲ್ ಮಾಡಕ್ಕೆ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಸ್ಟಮ್
ಮೇಬಿ ಇಟ್ ಲ್ಯಾಕ್ಸ್ ಟುಗೆದರ್ ಆಗುತ್ತೆ.
ಎಷ್ಟಾಗತ್ತೆ ಹೇಳಿ? ಅದು I'll ask him to install it, get your certification and then
That
direct
is
them
the
to.
main issue.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಚೆಕ್ ಬ್ಯಾಕ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ರೌಂಡ್ ಬಿಲ್ಡಿಂಗ್ ಮೂವ್ಮೆಂಟ್ ಮಾಡಿ ಕಟಿಂಗ್ ಮಾಡಿ ಈಸಿ ಆಗಿ ಸರ್ ಈಗ ನಾವು ಸೆಟ್ ಬ್ಯಾಕ್ ಯಾಕೆ ಕೇಳ್ತಾ ಇದೀವಿ ಅಂದ್ರೆ ನಮ್ಮ ಫೈರ್ ಸರ್ವಿಸ್ ವೆಹಿಕಲ್ ಏನಿದೆ ರೌಂಡ್ ದ ಬಿಲ್ಡಿಂಗ್ ಮೂವ್ಮೆಂಟ್ ಮಾಡಿ ಫೈರ್ ಫೈಟಿಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅದನ್ನ ನಾವು ಕೇಳ್ತಾ ಇರೋದು. ಬಟ್ ಈಗ ಮೇನ್ ಅದೇ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಈಗ ಫೈರ್ ಫೈಟಿಂಗ್ ಮಾಡೋದೇ ಕಷ್ಟ ಆಗುತ್ತೆ. ಅದೇ ಲ್ಯಾಬ್ಸ್ ಇದೆ ಸರ್. ಸೆಟ್ ಬ್ಯಾಕ್ ಅಂದ್ರೆ ಅದೇ ಲ್ಯಾಬ್ಸ್ ಇದೆ.
ಆಯ್ತು, ನೀವು ಹೊಡೆದಕ್ಕೆ ಪವರ್ ಇದೆಯಾ ನಿಮ್ಗೆ ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ?
ಯಾವ್ದು ಸರ್?
ಬಿಲ್ಡಿಂಗ್ ಹೊಡೆದಕ್ಕೆ ನಿಮ್ಗೆ ಪವರ್ ಇದೆಯಾ?
ನಮಗೆ ಪವರ್ ನಾವು
ನೀವು ಬರೀ NOC ಕೊಡಲ್ಲ ಅಷ್ಟೇ.
ಸರ್ ಹೌದು, ಆಸ್ ಪರ್ ಇದು ಗೈಡ್ಲೈನ್ಸ್ ನಾವು NOC ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
This can't be a functional system. You allow the building to be constructed.
And it is the burden of the owners to take care of all those things, your lordship. They have to get the certificate from the builders, your lordship. Here the builder has to answer.
From whatever is suggesting, virtually the apartment complex have to be demolished.
Not in.
Yes. If he has to give 11 meters setback on the two sides, that is 33 feet. They'll have to remove the entire building. If they have to remove the entire building, virtually the entire complex will have to.
Then it is a mistake of the builder, your lordship. Builder has to come and answer.
Then who allowed this to happen?
It is for the safety of the owners only
Who
we are.
allowed this to happen? Who allowed the building to be constructed? Who allowed the power to be granted? You take action against them.
Get the
The
instruction.
fire department by granting an NOC
Yes, your lordship.
should also inspect and see whether the building is built in accordance with the NOC that is granted. What steps did the fire department take? They can't walk in after the building is over and then say, I will not grant NOC. If their ultimate objective is to see that a fire hazard happens and they can take care of it, they should monitor this, isn't it?
Yes, your lordship.
ಸರ್ ಈಗ ಫಸ್ಟ್ ನಾವು NOC ಕೊಡೋದು ಓಪನ್ ಸ್ಪೇಸ್ ಇದೆ. ಓಪನ್ ಸ್ಪೇಸ್ ಅಲ್ಲಿ ನಾವು ಇಷ್ಟು ರಿಕ್ವೈರ್ಡ್ ಸೆಟ್ ಬ್ಯಾಕ್ ಕಟ್ ಬಿಡ್ಬೇಕಂತ ಹೇಳಿ ನಾವು NOC ಕೊಟ್ಟಿರ್ತೀವಿ ಸರ್. ಆ ಪ್ರಕಾರ ಅವರು ಕಟ್ಟಬೇಕು.
ಆಮೇಲೆ ನಿಮ್ದೇನು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಏನಿಲ್ಲ.
ನಂತರ ಅವರು ಕಂಪ್ಲೇಂಟ್ಸಿಗೆ ಬಂದಾಗ ಅದನ್ನ ನಾವು ರೆಕ್ಟಿಫೈ ಮಾಡ್ತೀವಿ ಸರ್. ವೆದರ್ ಅವರು ಆ ತರ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದಾರ ಅಥವಾ ಇಲ್ಲ, ಆ ನಂತರ ನಾವು ಕ್ಲಿಯರೆನ್ಸ್ ಕೊಡೋದು ಸರ್.
So you will allow the building to come up and thereafter say, I didn't know, therefore I can't give NOC.
Because builders responsibility sir. As per the NOC.
ಅವ್ರ ಒಬ್ಬರದೇ, ಬೇರೆ ಯಾರ್ದು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇಲ್ಲ ಅಂತ ನೀವು ಹೇಳೋದು. ನಿಮ್ದು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇಲ್ಲ, BBMP ಇಲ್ಲ, ಯಾರ್ದು ಇಲ್ಲ, ಬರೀ ಅವ್ರ ಒಬ್ಬರದೇ. ಅವ್ನ್ ಕಳ್ತನ ಮಾಡ್ತಾನೆ ಇರ್ತಾನೆ, ನೀವು ಸುಮ್ಮನೆ ನೋಡ್ಕೊಂಡಿರ್ತೀರಾ. ಕಂಪ್ಲೇಂಟ್ ಬಂದಾಗ ನಾವು ಆಕ್ಷನ್ ತಗೊಳ್ತೀನಿ ಅಂತೀರಾ ಅಲ್ವಾ? In the given building that exists as on today, can a fire protection system be installed? Then first ಹೇಳಿ, ಆಮೇಲೆ I'll deal with the setback.
ಈಗ ನಾವು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿವಿ, ಅನಂತರ ಅವರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದ್ರ ಬಗ್ಗೆ ನಮಗೇನು ಮಾಹಿತಿ ಕೊಡ್ಲಿಲ್ಲ ಸರ್. ಈ ತರ ನಾವು
ಅದಕ್ಕೆ ಇವಾಗ ನೀವು ಫೈರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಸ್ಟಮ್ ಏನ್ ಇನ್ಸ್ಟಾಲ್ ಮಾಡಬೇಕು ಅಂತ ಕೊಟ್ರೆ ಅದನ್ನ ಅವ್ರು ಇನ್ಸ್ಟಾಲ್ ಮಾಡಾದ್ಮೇಲೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ಗ್ರಾಂಟಿಂಗ್ ರೆಸ್ಟೋರೇಷನ್ ಆಫ್ ದಿ ಪವರ್. ಅದನ್ನ ಮಾಡಕ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಹೇಳಿ.
ಆಯ್ತು, ನಾವು ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿ ಕೊಡ್ತೀವಿ.
The fire officer is present before the court today as ordered. He submits that the spot inspection will be conducted and the fire protection system that is required to be installed will be informed to the association. ಯಾವತ್ತು ಮಾಡ್ತೀವಿ?
Immediately
released on Thursday.
20th.
ನೀವು ಬರೀ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಅದನ್ನ ನಿಮ್ ಫಸ್ಟ್ ಫೈರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ದೆನ್ ಐ ವಿಲ್ ಎಕ್ಸಾಮಿನ್ ವಾಟ್ ಇಸ್ ಟು ಬಿ ಡನ್.
Number 31, Shri Balraj K. Shirajin Basha.
Petitioner, my lord, asking for a refund of the deposit amount on the basis of the acquittal by the trial court on the ground that on the benefit of doubt, the trial court has acquitted the petitioner. On that ground, my lord, the petitioner asking for refund of the amount deposited before the appellate authority. Earlier, my lord, he tampered the meter and also the seal. On that ground, my lord, the back billing notice was issued. That was challenged before the trial court. The trial court in OS, my lord, dismissed the suit. Against that, he filed RA. RA was also dismissed and appeal filed before this honorable court in RSA, my lord. In RSA, my lord, this honorable court, this is not a jurisdiction, my lord, and directed to deposit 50% of the amount and directed to file an appeal before the appellate authority. Appellate authority, my lord, after considering the argument, confirmed the back billing amount, my lord.
Where is the order of
Petitioner, my lord,
Where is
annexure,
where is the order of the criminal court?
criminal court order, my lord, I will ಕೊಟ್ಟಿದ್ದೀಯ ನೋಡಿ ಮುಂಚೆ ಏನಾರ ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ.
If you are unable to establish the meter was tampered,
Yes, my lord.
then what should happen?
That back billing was confirmed, my lord. Because it is the duty of the petitioner to establish, my lord, it is not tampered. This honorable court in division bench, my lord, clearly stated that it is the duty of the petitioners to establish.
What was the charge before the criminal court?
Criminal court, the same theft case, my lord, 135.
So if that theft is not established, what is the effect?
On benefit of doubt, my lord, it is acquitted.
It is an acquittal, benefit of doubt and it is an acquittal.
Yes, my lord.
Then what should happen? You're not able to establish that there was theft.
No, kindly see, my lord, this is the two judgments, my lord. This honorable court has passed the orders. One code. One code. Done. In writ appeal 17962 of 2011, my lord. In 2013, the division bench has held that para 3, my lord. Para 3, 5 and 7, my lord.
ಯಾವ್ದು ಹೇಳ್ತೀರಿ ನೀವು? Writ appeal 17962.
17962. Para 3, para 5 and 7, madam.
Who appears for the petitioner? ಒಂದೇ ಗ್ರೌಂಡ್ ಹಾಕಿರೋದವ್ರ?
Only, that is the only ground, my lord. In the writ petition also. In another judgment also, my lord, in para number 5, this honorable court has clearly stated that, my lord.
The petitioner challenges an order passed by the appellate authority by which the appeal filed by the petitioner regarding the back billing demand raised has been confirmed. A back billing demand was raised in view of the fact that the authorities noticed a dishonest abstraction of energy from the petitioners. The petitioner contends that he was prosecuted on the criminal side and he was ultimately acquitted, and therefore the order of the appellate authority affirming the alleged dishonest abstraction of energy was incorrect. A division bench of this court in writ appeal number 17962/2011, while considering regulation 42.06, has held as follows, para 7. In view of the above, the mere acquittal of the petitioner in the criminal prosecution would not entitle him to seek for quashing of the demand for back billing. The petition is accordingly dismissed.
Serial number 32 for adjourned. Serial number 35. Sheshgiri Rao. Sheshgiri Rao.
Lords, kindly, I praise time. It may be adjourned on Tuesday, my lords.
I had already adjourned it once.
My lord, senior is not there in the station, my lords. He is in Dodbalapur. He was not able to reach in time. It may be posted on Tuesday only, my lords.
You should get ready. If he is not ready, you can't wait for him. The last chance, we list on
21st.
Next time, if he's not here, I'll decide with you or without you.
I'll get ready, my lords.
21st.
Much obliged.
36 to 38 adjourned. Serial number 39. Shri Surendra Babu.
My lord,
Serial number 30.
petitioner's counsel, my lord, requested me that he is not able to reach from Tumkur. It may be adjourned on a future.
21st. Serial number 40. Shirish Krishna. Shirish Krishna.
List.
21st. Serial number 41. Shri Jagan Mohan.
List.
Serial number 42. Shri Ashwatthappa D.
Shotappa illa.
List. 21st. Serial number 43. Shri Shri Shankar Reddy.
List.
44 and 45 adjourned. Serial number 46. Shri Keshav Datar.
10th order.
21st. Serial number 47. 47.
Petitioner. Devraj time ತಗೊಂಡಿದ್ದಾರೆ.
Serial number 49. In Nataraj Ballard. Serial number 52 adjourned. Serial number 53. Civil Prasad Pass. 54 adjourned. Serial number 55. Shri Mohan Baleshwar Bhatt. Serial number 56. Shri Prashant VG.
May I please your lordships?
Yes.
My lord, I am appearing by VC. The matter is ready for hearing. Could my lords kindly have it on Tuesday? I'll appear physically.
What date is today? 20th.
Grateful, my lord. Extremely great.
Serial number 57. Aditya Narayan.
Appearing to the petitioner, my lord.
Appear for the respondent in this matter, your lordship.
Yes.
Your lordship, we have to file the objection. I just seek 1 week's time to file the objection in this matter.
My lord, the interim order may be extended.
21st. Serial number 58 to 60 adjourned. 61 adjourned. Serial number 62. DS Wasmat. DS Wasmat.
List.
Serial number 63. Shri Bhargav Ji.
List. ಯಾರು ಮೂಡಿದ್ದಂಗಿಲ್ಲ ಅವರು.
21st.
21st. ಅವತ್ತು ಹಂಗೆ ಆಗುತ್ತೆ.
ಫ್ರೈಡೆ ಏನ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲರೂ?
Waiting for 2:30 matters, my lord.
ಮುಗಿಸ್ಬಿಡ್ದು ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ರೀ.
Great.
64 adjourned. Serial number 65. Shri G.V. Nandesh Gowda.
List.
Seal number 66.
Respondents, my lord.
65, 21st.
Please, ma'am, wait.
66, Shri B.R. Satyanali. Seal number 67, Shri B.C. Sitaram Rao.
And for respondents.
21st. Seal number 68, Shri Joseph Anthony. Seal number 69, Shri Mati Purnima Hatti.
My lords, I am present appearing for the petitioner, my lords.
Yes.
My lords, this was on the last occasion it had come up. This is a labor cess matter, my lords. We are acting on behalf of the petitioner which set up certain transformers and related construction for KPTCL, my lords. And actually in the response, they have conceded that for 2 projects, they have to return the cess that has been deducted. And so far as the other 3 projects, my lords, they have deducted cess not only for construction, but also supply of materials, my lords. So it's a settled position, my lords, that under the Act, only for construction the cess has
Who's
to be
opposing
deducted.
you?
My lords,
Shri
I
Vish Krishna.
understand.
He's not here. I'll take it up next week.
21st.
Grateful. Please,
Seal
ma'am.
number 70, Shri A.L. Krishna.
Lord, here and we have the respondents. NEFT, can I?
The
NEFT,
online payment.
online payment. Please, ma'am. My lord, can it kindly be passed over, ma'am?
In this much I am told that's in Dharwad bench, was this honorable court had in similar set of circumstances, Malas had directed, rather Malas, there was no specific direction, but Malas, the High Court had undertaken that they will formulate a rule even in respect of Malas, these kind of deposits. And I'm told pursuant thereto, Malas, it has been placed before the rule framing committee and the matter is pending adjudication there. So what I would request is, Manoj, if they can point out their grievance and make a representation, Manoj, to this honorable court.
No, I'll pass
Lordship
it.
may direct the registry or the on the administrative side, let the High
Pending
Court-
the framing of a rule.
Yes.
I'll issue a direction for you to ensure that online payment by the insurance
No, what I
companies-
was told is, Manoj, today what is happening is when online deposit is made, they will not get to know as to who has deposited in respect of which case it is being done.
You tell us the mechanism whereby that.
Correct, Manoj. I'm told, Manoj, they are, because once they said it has to be done by the government in terms of the Khazana too. But Manoj, when I checked with them whether there is any specific rule as to how it is to be done with regard to the details of the case to be entered, which party is making deposit.
Tell me which officer from the treasury should come and tell you. I'll ask him to be present. You writing a letter, they not responding, it will take, it's been almost.
No, what I'm saying today is, Manoj,
You need
And
a
if-
mechanism, isn't it, from Khazana too?
Yes.
To ensure that the payment is permissible through online.
yes. No, Manoj, permitting them to take it online, Manoj, is not an issue. What is happening is, Manoj, the details of the case are not as on date, Manoj, the software or the entry to be made does not indicate the case number, the party's name. So whenever a deposit is, suppose the deposit is done from Bombay.
Who should do that? Who should provide for that mechanism to incorporate the case number instead of which the
I was told, Manoj, that it is to be done by the state government because whatever deposit is made, it is going to the
Department
Khazana
of the-
too.
Which department of the state government, which officer? I'll ask him to be present.
Yes,
So
Manoj.
he will, this matter can be expedited.
Very well. I'll just find out that, Manoj. Department, Manoj, Khazana too is, let me just find out, Manoj, which department has to do
He'll
it.
pass it over, get
Similar orders
Very
are
good.
passed in Tamil Nadu also. My lord, I have annexed the 2 decisions of Madras High Court. And also Rajasthan High Court also has passed it. And very recently, the motor vehicle rules also provides that it has to be through only NEFT. This is the latest trend.
ಅಲ್ಲ ಇವಾಗೆಲ್ಲಾನು ಮದೇ ಮಾಡ್ತೀರಿ ಇದೊಂದಕ್ಕೆ ಯಾಕೆ?
ನಾವು ತಗೊಳ್ಳುವಾಗ ನಮಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಾವು ಕಟ್ಟೋದಿಕ್ ಬಿಡೋದಿಲ್ಲ. And interest I have to pay till it is informed to the party.
Let me find out, Manoj, Treasury Department, Bharat Ansatte, Manoj, let me just find out as to who's the.
Pass it over, find out which officer will ask me to be present on the next date.
Very good. No, what I'm.
Because they won't move, Rajendra, they will not take one.
Correct, no, what I am saying is, Manoj, today Unless, my lords, this honorable court frames a rule indicating as to what is the
We will
procedure to
take-
be
we will
followed.
Take our own time to frame the rules.
Yes,
Pending framing of the rules, let there be a judicial order which can be implemented or which
Correct.
can be made implementable. Let us get the officer in charge to tell us how it can be implemented.
very good, please. Then your lordship may pass it over, my lords. Let me
First
just
rule
find out.
making authority, then full court,
Oh.
government, that will take 1 more year.
Correct.
They've been waiting now for 7 years.
Yes,
I'll pass you or find out which officer is
please,
to.
please. I'll do.
230 more matters. Fresh matter, serial number 1. The Ankit is ready.
You have the petition speech. This is with respect to an FIR that has been lodged against the hospital and the doctor, which accused number 2 is the doctor, Dr. Nupur Sood, who also co-owns the hospital. Now, my lords, the facts of the matter is this, that the complainant's wife was admitted in the said hospital and has undergone a C-section. The mother and child have been discharged 2 days later. Subsequently, she's developed some sort of a pain in her uterus and she's gotten admitted in another hospital in Mysore. Further to certain tests, it was found that there's a foreign body and she had to be reoperated. Subsequent to which she has been discharged and she's hale and healthy. Now, my lords, the complaint came to be filed on 28/5/2024 before the concerned police. And the very same day, they have registered the FIR. My concern with respect to this is, my lords, that whenever there is an FIR or any sort of a complaint against a medical professional, it has the expert opinion of the
Was anything enclosed by her to indicate the foreign object left behind by?
No, my lords. There's absolutely nothing. The FIR is silent, so is the complaint. The complaint, my lords, is at page number 11 onward, 12 onwards.
She says after multiple scans, it was discovered that a foreign object was left inside her stomach.
Yes, my lords. There's no, my lords, however, there should be a expert medical opinion to show that there has been some sort of a grave.
Question is, was the scan report?
No, my lords. There's nothing to show that there was a scan report that has been annexed. And if at all there it was, it should have been reflected in the FIR. The FIR is also silent. It's a mere translation of the complaint into the FIR.
Issue notice. This shall be an interim stay of all further proceedings. Pursuant to the FIR that has been registered against the petitioner.
Previously.
DCP takes notice for the first response.
Serial number 2.
Lodge one submission, maybe directly to inform the respondent police, not to that the.
Granted, stay, what else you want?
Serial number 2, Shishdhar Prabhu.
My lord, yesterday, my lord, lordships were pleased to pass an interim order in an identical matter. The transmission charges, my lord, I am passing on lordship's order passed yesterday in an identical matter where prayers are, my lord, identical to this petition. May I pass on? Parties are same, prayer is also same.
What is the interim order they had granted? As prayed for her.
Yes. The prayer is not page number 80.
I thought it was in terms of some other order that had passed.
Yes, my lord. It was in terms of some other order, actually. But it
No, I had said in terms of they have written interim stay as sought for.
that my lord, in fact, I'll pass on that also, my lord, that writ petition number.
No, I thought I dictated that, but I have signed this.
Yes, I remember, my lord. It was dictated as the Dharwad bench matter, my lord. Sorry. It is all are same, my lord. As prayed for andru ade, interim order andru ade. Eradu ande. Because that is also, I'm sorry. Should I pass it on that Dharwad bench?
Where is that Dharwad bench order?
No, I'm sorry, we are not carrying it yet. I'll ask my colleague to right now reach it to the court office.
Interim order in terms of.
I'll reach it out.
Post
Right.
along with WP 15429/2020. And delivery permitted.
Grateful.
For hearing B group, seal number 3, Shri Madheva KR.
Kind permission. Sorry for the interruption, my lord.
Yes.
My lord, one submission. Since, my lord, the matter pertaining to Dharwad bench where the lordship, since I was on my legs in court, lord, I could not appear before the lordship when the matters were called out.
Next
Lord,
Friday
see. How serial number 4, 5, 6 and can be disposed of since, my lord, already the lordship has passed an order in all the cases where co-accused have been already, lordship has passed the proceedings. 4, 5 and 6. Those judgments are part of the petition itself.
No, but that's why I wanted you to come and say, or else I didn't
Allah,
want
the
to-
court all 4, I was on my legs in court all 4, my lord, since I could not appear. Sorry for the inconvenience, my lord.
It is not in dispute that in respect of the co-accused, this court in so-and-so has already quashed the proceedings. In the same principle, this petition is also allowed. And the persons as against the present petitioner was accused number so-and-so shall also stand quashed. 4, 5, 6. No.
Please, madam. I accept notice on behalf of the respondents.
Yes, consumer accepts notice for respondents.
Please. Please.
Seal number 3, Shri Madheva KR.
Based on 21/6/2024 as already ordered. ಏನಿದೆ ಮಾಡೋದು? ಏನು ಮೋಸ ಅಂತ ಹೇಳಿದ್ರು?
ಅದು ಪ್ರಾಪರ್ಟಿ ರಿಲೀಸ್ಗೆ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ರೆ ಮಿಲಾಟ್ಸ್. ವೆಹಿಕಲ್ ರಿಲೀಸ್ಗೆ. ಬಟ್ section 451 of CRPC ಮಿಲಾಟ್ಸ್ it clearly says.
Asked our matter, Sri N. Krishna Swami.
No doubt.
In para 10 of the objections filed by the High Court, it is stated that the High Court is in the process of making payments through the system of Khajani 2. And if the same is being implemented, all transactions pertaining to payments should become quicker and would not cause any hardship to the litigants. It is however not clear as to the progress that has been made in this regard. So, not counsel for the High Court submitted that there is a difficulty in permitting an online deposit since the details in respect of which the deposit was being made cannot be indicated along with the deposit. In regard to the fact that the High Court is adopting Khazanah 2, it would be appropriate to direct the concerned officer from the Treasury Department who is in charge of Khazanah 2 to appear before the court and state as to in what manner the problems faced in the online deposit, both by the litigants and the High Court, can be resolved. Relist on. Please inform Rajendra. The concerned officer from Khazanah should come.
Yes.
Concerned officer from Khazanah should come. Khazanah 2.
Please.
Treasury ಯಾರಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ನೀವು ಯಾರಂತ ಹೇಳಿದ್ರೆ ಅವ್ರನ್ನ ಇಲ್ಲಿ ನೀವು ಕೇಳ್ಕೊಂಡು ಯಾರು ಆಫೀಸರ್ ಹೇಳಿ ನಾನು ಆಮೇಲೆ ಅಲ್ಲಿ ಇನ್ಕಾರ್ಪೊರೇಟ್ ದಟ್ ಇನ್ ದಿ ಆರ್ಡರ್. ಖಜಾನೆಗೆ ಯಾರೋ ಬೇರೆ ಯಾರೋ ಇನ್ಚಾರ್ಜ್ ಐ ಆಮ್ ನಾಟ್ ವೆರಿ ಶೂರ್. One person had come one day. Find out who is it. Wait for it, just 21st.
Serial number 55. Serial number 55. I think it is adjourned, my lord, can be had on 20th, my lord.
Date ಕೊಟ್ಟಿದ್ದಾರೆ.
21st.
It will be taken up on 20th, my lord, instead of 20th.
My lord, serial number 49 also, my lord. I am for the respondent in that matter. They have filed a writ petition in the form of PIL, my lord. That maybe a short.
Nobody was here when the case was called. So
I am sorry, my lord. I was in the next court, my lord.
Some date is given.
21st.
Please, my lord. Shorter date, very well. Because my lord, it's an excise matter. My shop has been, their only contention is my shop is within the radius of 100 meters, which is not correct. My lord, the deputy commissioner formed an inquiry and then my lord, Mazar came to be drawn.
21st.
Shorter date, my lord.
18th is holiday.
Please, sir. Grateful, my lord.
Thursday, Friday, ಎರಡೇ ದಿನ.
sir.
Excuse me, court officer, ma'am. Court officer, ma'am.
ಹೇಳಿ
Ma'am,
sir.
hello. Sir, hello, sir. So what happened in serial number 40, 62, 68 and 69 in list 1?
Sir, you please tell me the serial number, sir.
So one by one, I'll tell you. 40. So serial number 40, sir.
40.
Yes, sir.
Sir, it's adjourned to 21st.
21st. And serial number 62. 62, sir.
It's also adjourned to 21st.
68, sir.
68. Same, 21st.
69, sir.
Same date. How many matters are there?
So one more, sir. Sorry, sir. One more. Sir, list 2, serial number 19.
It's dismissed for non-prosecution.
My God. Sir, list 2, serial number 19.
Dismissed for non-prosecution.
So court
Okay.
officer, serial number 66.
Thank you. Thank you.
Court officer? Sir, serial number 66, sir?
21st.
Okay, sir. Thank you, sir.
In terms of the order ಅಂತ ಅದರಲ್ಲಿ
ಅದು ಫೈಲ್ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀವಿ ತರ್ಸ್ಲಾ ಹೇಳ್ತೀನಿ ಇದೆ ಧಾರವಾಡ. ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿದೆ ಈ ಟರ್ಮ್ಸ್ ಆಫ್ ಅದು ನೋಡ್ಕೊಂಡು ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಏನಿರುತ್ತೆ ಅದು ಮಾಡಿ ಪೋಸ್ಟಲ್ ಹಂಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಆಮೇಲೆ ಬೇಡ ಧಾರವಾಡದಾಗ ಬೇಡ. ಯಾವುದು 3 ಡಿಸ್ಪೋಸ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ಸ್ ಡಿಸ್ಪೋಸ್ ಕನ್ಸಿಡರ್ ಇದಲ್ವಾ? Okay.
ಎಷ್ಟ್ ಬಿಟ್ರ ಸಾಹೇಬ್ರು? ಯಾವ್ದು ನಡೀಲಿಲ್ಲ ಬೇರೆ? ಮೇಡಮ್ ಹೊರಟೋದ್ರು. ಎಲ್ಲಿ ಎದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸಾಹೇಬ್ರು? ಎಲ್ಲಿದ್ದೀರಾ? Okay. ಅಲ್ಲ ನನ್ ಮತ್ತೆ ಯಾವ್ದಾದ್ರು ಬರ್ತೀರಾ? ಯಾವ್ದಿಲ್ಲಲ್ಲ? ನಾನು ಏಜ್ ಮೀಟ್ ಮಾಡ್ಸಕ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೆ. ಏಜಿನ ಮೀಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಅವ್ರನ್ನ ಸ್ವಲ್ಪ ಇದೆಯಲ್ಲ ಒಂದು ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ರೆ ಥೌಸಂಡ್ಸ್ ಆಫ್ ಅಮೌಂಟ್ ಬಂದ್ಬಿಡ್ತಾ. ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದಿಲ್ಲ.
21st.
Please, sir. 5-0. Sir, you're good. Okay.
Oh,
Bench 28.
ಸರ್ ನಂದು 61 ಸಿದ್ದರಾಮಯ್ಯ BB 21. ಓಹೋ ನೆಕ್ಸ್ಟ್ ವೀಕೆ.
Yes, Harvard ಮಾತ್ರ. That's what it is.
My lord.